all rise?
The Kosovo Specialist Chambers is now in session.
Please be seated.
Good morning, everyone. Before I start, I will give the opportunity to the photographers to take some photographs for a period of 1 minute, please. Madam Court Officer, would you please call the case?
Good morning, Your Honor. This is file KSC BC 2023-12, the Specialist Prosecutor versus Hashim Thaçi, Bashkim Smakaj, Isni Kilaj, Fadil Fazliu, and Hayreddin Kuçi. Thank you.
Thank you very much, Madam Court Officer. I am Christopher Gosnell, the single trial judge in this case. I sit in this case as a single judge pursuant to Article 15.2 of the Law on Specialist Chambers, which so permits in respect of crimes not classified as serious crimes under Article 22 of the Kosovo Criminal Procedure Code. Pursuant to Rule 124.1 of the rules, I hereby open this trial and ask the parties to introduce themselves and their respective teams, starting please with the prosecution.
Good morning, Your Honor. Thank you. Josh Hafetz on behalf of the Specialist Prosecutor's Office, and I'm joined by my colleagues, the Specialist Prosecutor Kimberly West, Matthew Halling, Lena Peterson, Claire O'Connell, Brent Hicks, and Earl Sullivan.
Thank you very much. In the order on the indictment, Mr. Thaçi, please.
Good morning, Your Honor. My name is Sophie Ménégon. I'm Specialist Counsel for Mr. Hashim Thaçi, and today I am with Leah Alix Cornelissen, Megan Hirst, Misha Gurejian Hall, and Mr. Lirim Gravesy. Thank you.
Thank you very much. Mr. Rees.
Good morning, Your Honour. My name is Jonathan Ellison, Rees King's Counsel. I am counsel for Mr. Smakaj. Mr. Hugh Bowden, to my left, is co-counsel, and we are assisted by the following team members present in court today: Mr. Stephen Lack, Muharrem Halalai, Nicholas Newson, and Matilda Folketta Hainsworth.
Thank you. Mr. Edwards.
Good morning, Your Honour. Behind me to the left is my team. Mr. Kilaj is represented and assisted by Hannah Chung, our intern, Admir Barisha, Omar Solomon, and then on my bench at the far right, Eva Kalb, my co-counsel, Joe Holmes of the Bar of England and Wales, Alexandra Baer of the Bar of Quebec, and myself, Ian Edwards.
Thank you. Mr. Young.
Your Honour, good morning. I appear for Mr. Fadil Fazliu today. I'm assisted in court today by Ms. Yu Ching to my left, and I'm assisted remotely by Ms. Bachiri and Ms. Vellieu. Thank you.
Thank you. Mr. Admiral. Madam Registrar? The charges in this case were confirmed by the pretrial judge on 29 November 2024, who issued arrest warrants for Misters Thaçi, Smakaj, Kilaj, Fazliu, and Kuchi, and Fazliu, and a summons to appear for Mr. Kuchi. On 8 and 9 December 2024, the initial appearances of the accused took place. During those appearances, or in subsequent written pleas, all the accused pleaded not guilty to the charges. On 16 April 2025, further to a decision by the pretrial judge authorizing the addition of a mode of liability in respect of Mr. Thaçi, the specialist prosecutor submitted an amended confirmed indictment against the 5 accused, which sets out the charges against them in this case. I shall refer to this as the indictment. On 12 November 2025, the pretrial judge transmitted the case file to me as the single trial judge. On 28 November 2025, the trial preparation conference and the specialist prosecutor's preparation conference were held pursuant to Rules 118 and 119. On 4 December 2025, I scheduled the start of trial for 24 February 2026, which I subsequently postponed to today at the request of the Thaçi defense. I also note that I ordered the provisional release of Mr. Kilaj on the 3rd of December 2025 and the provisional release of Mr. Smakaj and Mr. Fazliu on the 3rd of February 2026. Pursuant to Rules 124 and 125, the specialist prosecutor will be invited today to read a summary of the indictment. I note that the accused have consented to the reading of a summary instead of the entire indictment. I will then ask the accused whether they understand the indictment and to confirm their initial pleas of not guilty. I will then, pursuant to Rule 125, inform the accused of their rights and obligations. We will then hear opening statements from the prosecution and from those defense teams that have elected to present their opening statements now, rather than at the opening of their own cases. We will then proceed with the testimony of the first prosecution witness, Witness 7. In light of the slight delay this morning, we'll proceed now until 11:30 and then resume then again at noon. And we'll see whether or not we can make up the extra half hour over lunch after I consult with the registry as to whether or not that's feasible. Mr. Prosecutor, the floor is yours to read a summary of the indictment. And please speak at a moderate pace so the interpreters can do their work.
Thank you, Your Honor. I'm going to turn that over to my colleague, Mr. Hicks.
Good morning, Your Honor. The direction is well taken to speak moderately, and I will do my best for the interpreters. You've already defined the date of the indictment, and just for the clarity of the record, references to KCC, when I read the summary, are to the Criminal Code of the Republic of Kosovo, code number 06/L-074 of 2019. References to the law are to the law number 05/L053 on Specialist Chambers and Specialist Prosecutor's Office. Hashim Thaçi is individually criminally responsible for count 1, attempted obstruction of official persons in performing official duties by participating in the common action of a group between at least 26 June and 18 July 2023, a criminal offense against public order punishable under KCC Articles 17, 21, 32, 1 and 3, 35, and 401, 2, 3, and 5, and Articles 15, 2, and 16, 3 of the law. Count 2, attempted obstruction of official persons in performing official duties by participating in the common action of a group between at least 9 September and 30 October 2023, a criminal offense against public order, punishable under KCC Articles 17, 21, 32(1) and 3, 35, and 401(2), 3, and 5, and Articles 15(2) and 16(3) of the law. Count 3, attempted obstruction of official persons in performing official duties by participating in the common action of a group between at least 6 October and 2 November, a criminal offense against public order, punishable under KCC Articles 17, 21, 32(1) and 3, 35, and 401(2), 3, and 5, and Articles 15(2) and 16(3) of the law. Count 4, violating secrecy of proceedings through unauthorized revelation of secret information between at least 26 June and 18 July 2023, a criminal offense against the administration of justice and public administration, punishable under KCC Articles 17, 21, and 392(1), and Articles 15(2) and 16(3) of the law. Count 5, violating secrecy of proceedings through unauthorized revelation of secret information between at least 9 September and 30 October 2023, a criminal offense against the administration of justice and public administration, punishable under KCC Articles 17, 21, and 392(1), and Articles 15(2) and 16(3) of the law. Count 6, violating secrecy of proceedings through unauthorized revelation of secret information between at least 6 October and 2 November 2023, a criminal offense against the administration of justice and public administration, punishable under KCC Articles 17, 21, and 392(1), and Articles 15(2) and 16(3) of the law. Count 7, violating secrecy of proceedings through unauthorized revelation of the identity and personal data of a protected witness between at least 6 October and 2 November 2023, a criminal offense against the administration of justice and public administration, punishable under KCC Articles 17, 21, 392(2), and Articles 15(2) and 16(3) of the law. Count 8, contempt of court, between at least 26 June and 18 July 2023, a criminal offense against the administration of justice and public administration, punishable under KCC Articles 17, 21, and 393, and Articles 15(2) and 16(3) of the law. Count 9, contempt of court, between at least 1 and 13 September 2023, a criminal offense against the administration of justice and public administration, punishable under KCC Articles 21, 35, and 393, and Articles 15(2) and 16(3) of the law. Count 10, contempt of court, between at least 9 September and 30 October 2023, a criminal offense against the administration of justice and public administration, punishable under KCC Articles 17, 21, and 393, and Articles 15(2) and 16(3) of the law. Count 11, contempt of court, between at least 6 October and 2 November 2023, a criminal offense against the administration of justice and public administration, punishable under KCC Articles 17, 21, and 393, and Articles 15(2) and 16(3) of the law. Bashkim Smakaj is individually criminally responsible for count 12, attempted obstruction of official persons in performing official duties by participating in the common action of a group between at least 9 September and 30 October 2023, a criminal offense against public order punishable under KCC Articles 17, 21, 33, 35, and 401(2) and 5, and Articles 15(2) and 16(3) of the law. Count 13, contempt of court, between at least 9 September and 30 October, a criminal offense against the administration of justice and public administration, punishable under KCC Articles 21, 33, and 393, and Articles 15(2) and 16(3) of the law. Isni Kilaj is individually criminally responsible for count 14, attempted obstruction of official persons in performing official duties by participating in the common action of a group between at least 6 October and 2 November 2023, a criminal offense against public order punishable under KCC Articles 17, 21, 33, 35, and 401(2) and 5, and Articles 15(2) and 16(3) of the law. Count 15, contempt of court, between at least 6 October and 2 November 2023, a criminal offense against the administration of justice and public administration, punishable under KCC Articles 21, 33, and 393, and Articles 15(2) and 16(3) of the law. Fadil Fazliu is individually criminally responsible for count 16, attempted obstruction of official persons in performing official duties by participating in the common action of a group between at least 26 June and 18 July 2023, a criminal offense against public order punishable under KCC Articles 17, 21, 33, 35, and 401(2) and 5, and Articles 15(2) and 16(3) of the law. Count 17, contempt of court, between at least 26 June and 18 July 2023, a criminal offense against the administration of justice and public administration, punishable under KCC Articles 21, 33, and 393, and Articles 15(2) and 16(3) of the law. Hayreddin Kuchi is individually criminally responsible for count 18, contempt of court, between at least 1 and 13 September 2023, a criminal offense against the administration of justice and public administration, punishable under KCC Articles 21, 35, and 393, and Articles 15(2) and 16(3) of the law. Count 19, contempt of court, on or about 12 April 2023, a criminal offense against the administration of justice and public administration, punishable under KCC Articles 17, 21, and 393, and Articles 15(2) and 16(3) of the law. This concludes the reading of the summary, Your Honor.
Thank you very much. I note that the accused are all present in court this morning, and I will now give the opportunity to each of them, pursuant to Rule 124(3), to state whether they understand the indictment and to confirm their pleas. Mr. Thaçi, could you please stand? Mr. Thaçi, do you understand the indictment against you?
Yes, I do.
Thank you. On January 6th, you pleaded not guilty to all counts of the initial indictment. And on 24 April 2025, you pleaded not guilty to all counts of the amended indictment. Do you confirm this plea of not guilty?
Plötsligt i pafajsho.
I plead not guilty. I'm entirely not guilty.
Thaçi, you may be seated. Mr. Smakaj, could you please stand? Mr. Smakaj, do you understand the indictment against you?
Yes, I do, Your Honor.
On 6 January, you pleaded not guilty to all counts of the indictment. Do you confirm your plea of not guilty to the charges against you?
Yes, I do confirm that. I am totally not guilty. I plead not guilty for the 2 points in the indictment against me.
Be seated. Mr. Kilaj, could you please stand? Mr. Kilaj, do you understand the indictment against you?
Yes, I do.
During your initial appearance on 9 December 2024, you pleaded not guilty to all counts of the indictment. Do you confirm your plea of not guilty to the charges against you?
Yes, I do. I plead not guilty.
Mr. Kilaj, you may be seated. Mr. Fazliou, could you please stand? Mr. Fazliou, do you understand the indictment against you?
Yes, I do.
During your initial appearance on 8 December 2024, you pleaded not guilty to all counts of the indictment. Do you confirm your plea of not guilty to the charges against you?
E konfirmoj plotësisht dhe krejtësisht i pafajshëm.
I do confirm that entirely. I plead not guilty for any of the counts in the indictment.
Basil, you may be seated. Mr. Cucci, could you please stand? Mr. Cucci, do you understand the indictment against you?
Po e kuptoj.
Yes, I do.
During your initial appearance on 9 December 2024, you pleaded not guilty to all counts of the indictment. You now have the opportunity to confirm this plea. Do you confirm your plea of not guilty to the charges against you?
Njëjtë e konfirmoj edhe sot që jam i pafajshëm.
I confirm the same before you today. I plead not guilty.
Thank you very much. You may be seated. Misters Thaçi, Smakaj, Kilaj, Fazliou, and Cucci, I will now inform you of some important rights that you are afforded before this court pursuant to its legal framework. You have the right to remain silent without such silence being a consideration in the determination of innocence or guilt. You have the right not to be compelled to confess guilt or to testify. You have the right not to incriminate yourself or your immediate family members. You have the right to be represented by counsel, and I note that each of you are indeed represented by counsel here. You have the right to have adequate time and facilities for the preparation of your defense and to communicate with your counsel. You have the right to be tried within a reasonable time. You have the right to examine or have examined the witnesses against you and to obtain the attendance and examination of witnesses on your own behalf. And you have the right to make an unsworn statement relevant to the case and may appear as a witness under oath. I'm also required by our rules to inform you of your obligations and measures provided pursuant to Rule 161.2 of the rules. As the single trial judge in this case, I oversee order in the courtroom and in the public gallery, as well as the conduct of all participants. Although I am sure this will not be necessary, I may order the temporary removal of an accused from the courtroom and continue the proceedings in your absence if you persist in disruptive conduct following a warning that such conduct may result in removal from the courtroom. During any removal, your interests will be represented by your counsel, and provisions will be made for any accused to observe the proceedings and to instruct counsel from outside the courtroom. And for everyone else in this courtroom and the public gallery, I may take appropriate measures as necessary to ensure the dignity and decorum of proceedings or for security reasons and to protect the right of the accused to a fair and public hearing, including ordering the removal or search of any person. Before proceeding with opening statements, a few ground rules for the proceedings are worthy of mention at this stage. Hearings will be held in open session unless otherwise requested by the parties. I invite the parties to request private or closed session when necessary, but would request that in general such references be avoided to the extent possible and that where necessary such questions be grouped together. I note that this case may involve information of significant sensitivity, so I would remind the parties to exercise great care to avoid revealing the names of any protected witness or other confidential information, whether during the course of public hearings or outside the courtroom. I would also remind everyone of the additional safeguards in place, namely the in-court redactions procedure set out in paragraph 10 of the decision on the conduct of proceedings, and also to remind everyone that evidence and other audiovisual materials shown in the courtroom, including whatever may be used today during opening statements, will not be broadcast publicly unless otherwise ordered by the single trial judge. Before I give the floor to the prosecution, I am required, pursuant to Rule 118.5, to set a target date for the closing of the specialist prosecutor's case. Given the time estimates of the parties for the examination and cross-examination of the SPO's witnesses, all SPO witnesses should be heard by Friday, 6 March 2026. As there may be motions regarding the admission of evidence, as well as an outstanding motion in respect of witness 8 that will need to be dealt with after his testimony, I hereby set the target date for the closure of the SPO case for Friday, 13th March 2026. I note that this is a target date only, and that a final date for the closure of the SPO case will be set after hearing submissions from the parties. I note that opening statements are not evidence, but rather a submission as to the facts that a party will endeavor to prove or its position on the law. Accordingly, I do not expect any objections will need to be made during the course of any party's opening statements. If exceptionally any party wishes to make such an objection, I request that they do so at the end of the opening statement. Mr. Prosecutor, the floor is yours. You have 1.5 hours, please. I see that Mr. Thaçi has raised his hand and seeks the floor. Does counsel have any idea what this may be about?
No, Your Honor. May I consult him?
Yes, please.
I thank you, Your Honor. You may proceed. Thank you.
Thank you. Mr. Prosecutor?
Thank you, Your Honor. Just 2 housekeeping matters to address one thing you just raised, and then on the timing. with the public issue in mind, all of our slides and demonstratives are intended to be shown entirely to the public live, and that's been communicated. They've been properly redacted if they need to be, so there is no need for that to be in private. And just for timing, Your Honor, and one other thing, there is no need for simultaneous translation of the audiovisual material that's played. It has translation rolling on the screen or in the exhibit itself. On the timing, will be a bit longer than 90 minutes with Your Honor's indulgence. We will definitely be under 2 hours, and it's broken in, just for planning purposes, into 4 parts. I'm going to turn it over to the Specialist Prosecutor in just 1 second for some introductory remarks. Then I will address the court, and then Mr. Hicks and Ms. O'Connell will briefly address the court on the law. Thank you.
That's fine. And in light of that assurance, then I order that the audiovisual materials may be broadcast publicly.
Thank you, Your Honor.
And just to remind the prosecution, you have until 11:30 for the, we'll be breaking at 11:30.
Understood, Your Honor. Thank you.
Good morning, Your Honor. Madam Registrar, and all in and around the courtroom. Your Honor, I'm pleased to have this opportunity to speak to you. Today, we come before you to address Hashim Thaçi and the other accused attempts to undermine and manipulate the framework of this court. They deliberately violated judicial decisions that were designed to ensure witnesses and victims could testify freely, without fear or influence, and could trust that their identities and words will remain confidential to the court and to the parties. Hashim Thaçi is charged with repeatedly and systematically attempting to interfere without witness testimony and with violating multiple court orders aimed at protecting confidential witness information. His co-accused are charged with unlawfully participating in these crimes. The conduct of the accused strikes at the very heart of the rule of law and this court itself, which exists within the Kosovo judicial system to ensure independent and fair and secure proceedings. That is why we are here. Whether the accused were successful in their efforts to influence witnesses does not matter. The reason we committed resources to this case is to protect the integrity of the proceedings in Case 6 and to ensure that the world and the Kosovo public understand that anyone who attempts to intervene in the truthful testimony of any witness we put before this court will be held to account. Upholding the rule of law means that no one is above the law. The law applies equally and everyone is accountable. And we know that the people of Kosovo take these charges as seriously as we do because the creation of this court included not only war crimes and crimes against humanity in its jurisdiction, but also specifically included the crimes charged in this case: obstruction of official persons in performing their duties, violating the secrecy of the proceedings, and contempt of court. We also know that the people of Kosovo want the rule of law upheld in their own courts, and that they recognize it as essential. And to the extent that a small but powerful group of people in Kosovo place their own private interests over all others, the facts of this case will expose and condemn that small group. As the court is aware, this case is primarily built on recordings and seized documents. You will hear the accused speaking among themselves, and you will see the documents they exchanged. And your determination as to what is intended by their words will be a major part of the case. But before I speak more on that issue, it is important to note now what this case is not about. This case does not concern the legitimate defense of Hashim Thaçi in his war crimes trial. Hashim Thaçi has a large defense team in that trial, and he had unsupervised access to members of his team through privileged meetings and calls. None of those meetings and calls have been recorded or observed. Nobody but Thaçi and his defense counsel know what was said in those meetings and calls. The only meetings and calls that were recorded pursuant to judicial authorization were unprivileged ones, with Thaçi knowing in advance that they were not meant to be used for unlawful contacts about witnesses. The fact that no privileged calls or meetings were recorded reflects the importance attached by all in the KSC and the SPO to the legal representation of accused. This prosecution is also not about policing word content, nor it is about the right of the accused to speak freely. And this case is not about Thaçi's right to challenge the charges against him in Case 6 or play an active role in his own defense. None of these things is a crime. And Thaçi had and continues to have all those important rights. What is criminal, however, is Thaçi's devising, instructing, and directing an extensive plan to influence witnesses and interfere with the free and fair administration of justice. What is also criminal is revealing confidential, protected witness information in violation of perfectly clear court orders. Court orders put in place to specifically ensure that witnesses feel safe to come here and testify before this court. And although the intent of Thaçi's recorded instructions was to make sure the expected witness testimony in his war crimes case, Case 6, was diluted and made less inculpatory to Thaçi's benefit, this case is not a determination of his criminal liability in Case 6. It is a determination as to whether Thaçi's instructions to influence witnesses and his disclosure of confidential court material in Case 6 are criminal violations separately in and of themselves. And Thaçi had a receptive audience in his co-accused. The recordings will show Hashim Thaçi's influence over the co-accused and the eagerness in which they willingly and enthusiastically engaged in his plan. In accused Fadil Fazliou's case, Fazliou offered up his own suggestions as to what the witness should say, and even use of his son to assist in the arrangements. In accused Isnia Kilaj's case, Kilaj received from Thaçi and took from the detention center copies of a witness's confidential prior statements for the specific purpose of interfering with the witness's testimony. Those documents, as you will hear, were later seized from Kilaj's home. In accused Bashkim Smakaj's case, Smakaj readily joined Thaçi's mocking of certain witnesses and received a 10-page printed document reflecting a narrative exculpating Thaçi's criminal responsibility in Case 6 and consistent with Thaçi's instructions to the targeted witnesses. That document, as you will hear, was later seized from Smakaj's car. In accused Radnai Kuchi's case, Kuchi repeatedly provided his own suggestions on what the targeted witnesses should say in order to benefit Thaçi. Indeed, Kuchi was well placed to make such suggestions, as he, at the time, had been representing co-accused Kadri Vaseli in Case 6 for over a year. The recordings in this case do not just reflect an agreement among the co-accused to commit crimes, but speak to loyalty and allegiance to the ringleader himself, Hashim Thaçi, and a clear commitment to do his bidding. All the charged conduct had a single and precise goal: obstruct and undermine the war crimes proceedings to the benefit of Hashim Thaçi. This conduct represents a clear and present danger to the rule of law, which requires that witnesses must be able to come to court and tell their stories free of pressure, influence, or interference of any kind. It is important for the legacy of this institution that these facts are adjudicated and aired publicly so that a true and credible record is created. It is just as important that we honor our commitment to the Kosovo public and the world by ensuring that we treat everyone equally and that no one is above the law. Your Honor, you will hear from my colleagues regarding more specifics of the case. Mr. Hafetz will summarize our evidence, including the recordings and the corroborating documentary evidence, and then Mr. Hicks and Ms. O'Connell will speak to you about the applicable law and elements. Thank you.
And tell him, simplify it. Don't get mixed up. Don't get mixed up, man. Tell him, be brief, be brief, be brief, be brief. Tell him, do not philosophize. They will give it to him, but he has to correct them. When he comes here, before entering the courtroom, he has to correct them. And tell him, you never saw the two of them from 94 to 98. Shut this down. These are all instructions issued by Hashim Thaçi to his co-accused in this case while he was detained here in The Hague in 2023. Thaçi's direct commands to his co-accused tell you exactly what this case is about. And that is Mr. Thaçi's sustained and systematic efforts to obstruct this tribunal's work by attempting to influence and interfere with witness testimony, revealing confidential witness information, and disregarding and disobeying clear court orders. The prosecution case will show that each Thaçi instruction, and there are many, many more in evidence, had a clear target and a clear goal. The targets were specific witnesses whose testimony Thaçi deemed a threat to him. And the goal was to neutralize each threat so that Thaçi could evade justice. And each of Thaçi's co-accused sitting here today were his willing and eager partners to achieve their common goal. Three of them, Mr. Fazliu, Mr. Kilaj, and Mr. Smakaj, did Mr. Thaçi's bidding in groups. The fourth, Mr. Kuchi, is charged with contempt of court for agreeing on his own with Mr. Thaçi to execute his instructions, and also, separately, for committing contempt of court in his own right by blatantly violating a court order. As the evidence will show, when Mr. Kuchi schemed with Thaçi to interfere with witness testimony, he knew the relevant rules he was breaking because he was also working as a defense team member for Kadri Veseli. Your Honor, the story of this case begins here in The Hague, and it begins with certain facts that are beyond reasonable dispute. On the 5th of November 2020, Mr. Thaçi was arrested and charged with 3 other former high-ranking members of the Kosovo Liberation Army for war crimes and crimes against humanity offenses arising from the 1998-99 war for the liberation of Kosovo. As the specialist prosecutor has already said, Mr. Thaçi is not on trial here now in this courtroom for those offenses. But it's a fact that if convicted of the charged offenses in that case, known as Case 6, Mr. Thaçi faces a lengthy prison term, providing a significant motive for him to use any and every means possible to avoid conviction. And Thaçi's detention center visits with his co-accused here, all loyal associates, became one of those means. Following his arrest in 2020, the Case 6 pretrial judge ordered Thaçi detained pending trial. In finding his detention necessary, the pretrial judge explicitly recognized the, quote, general, well-established, and ongoing climate of intimidation of witnesses and interference with criminal proceedings against former KLA members. That's an end quote. It is precisely because of that climate that these proceedings are taking place here in The Hague in the first place. As the pretrial phase of Case 6 progressed, the court issued judicial orders aimed at protecting from public disclosure the identities and other private information of a substantial number of prosecution witnesses. The court issued these measures to protect the witnesses from potential intimidation and interference. The court also issued strict contact protocols regulating the ability of the Case 6 accused to, number one, contact prosecution witnesses, number two, discuss the subject matter of witness testimony, and three, to reveal witness identities to anyone outside of their defense teams. One such order expressly prohibited the accused from contacting Case 6 witnesses, directly or indirectly, without the court's permission. In other words, this order meant that Mr. Thaçi was not allowed to use his friends and associates who visited him here in The Hague to contact SPO witnesses to tell them how to testify. With these judicial orders in place, and as the start of trial got closer, the prosecution began disclosing to Thaçi and the other Case 6 accused the identities of protected witnesses, along with their prior statements, the exhibits to be used with each witness at trial, and eventually the rough order in which the witnesses would appear. The court was explicit. Confidential witness information disclosed to the defense, including not just witness names, but even a person's status as an SPO witness, was to be protected at all times. During this time, including the entire indictment period in this case, which is April through October of 2023, Thaçi was detained pending trial at the KSC Detention Center. During his detention, Thaçi had certain rights and privileges, including the use of a computer to which no one else had access. Thaçi could use this computer to help prepare his defense by reviewing confidential witness material disclosed to him. He also had the ability, with the assistance of detention center staff, to print documents, including confidential SPO witness material. And in addition to his unconditional right to family contacts, he was also free to schedule in-person visits with his friends and associates. Throughout this period, the detention center had rules and regulations governing these visits. One rule was that all non-privileged visits, including all of Mr. Thaçi's visits with the co-accused in this case, must take place within the sight and sound of a detention center officer. Another rule was that detainees and their visitors were not permitted to exchange any items without the express prior permission of the head of the detention center. The rules were clear, the rules were public, and the rules were known to Thaçi and to all his visitors, including his co-accused. Your Honor, this is the factual and procedural backdrop for the charges in this case. And it is against this backdrop that Thaçi's trial in Case 6 began in April 2023. Together, it followed the combination of court orders, protective measures, and detention center visit regulations would prevent the witness interference and obstruction of court proceedings that this tribunal was designed to protect against, while simultaneously honoring Mr. Thaçi's right to a free and fair trial, his right to play an active role in his defense, including by accessing and even printing sensitive materials, and to maintain contacts not just with his family, but with a steady stream of visiting friends and associates. But that is not what happened. Thaçi and his co-accused in this case chose not to obey these court orders and rules. Instead, the evidence will show that nearly as soon as Case 6 began and witnesses started testifying, Mr. Thaçi became laser-focused on preventing testimony from witnesses who might damage his case. He obsessed in particular over what those witnesses would say about him, what their risks their testimony posed to him, to his case, and to his conviction. And then, determined to get the outcome he wanted, determined to minimize or eliminate any testimony he thought could hurt him, Mr. Thaçi shattered the KSC's detention and confidentiality rules, and he weaponized the system for his benefit. He turned the detention center and his constant visits with his associates there into a headquarters for attempted obstruction, where he repeatedly targeted witnesses for interference and whispered orders to his visitors on how the witnesses must testify to help his case. He abused the court's disclosure regime to mine the confidential witness statements disclosed to him, to identify, sometimes down to the line, precisely what he wanted each particular witness to change from their prior statements. And he then used his computer and printing access to provide detailed, hard copy interference instructions for his co-accused to execute. Mr. Thaçi targeted two types of witnesses. The first were former KLA insiders who Thaçi consistently and repeatedly identified as, quote, decisive, end quote, to his fate, and who were expected to testify about the structure and the inner workings of the KLA, including Thaçi's leadership role. The second type were specific victim witnesses who could directly implicate Thaçi in charged Case 6 offenses. He studied their prior statements, and then he systematically used his non-privileged visits to tell his loyal associates, including his co-accused, what needed to be done, what each witness needed to change from his prior statements or testimony, and when the witness needed to change it, what the witness needed to say in court, and how to say it, even how the witness should dress. To execute his demands, Thaçi formed discrete groups of his co-accused to target specific witnesses. These co-accused and the other uncharged group members consistently demonstrated their agreement to and participation in carrying out their common goal. For each attempt, Thaçi selected as his instruments of obstruction people who knew the witnesses, who had access to them, and had relationships with them. In Mr. Cucci's case, Thaçi did not rely on a group. Instead, he used a non-privileged visit with a member of another Case 6 defense team member to try and interfere with multiple witnesses, including two KLA insiders and an alleged victim of mistreatment by the KLA. We see Thaçi's obstructive conduct at work on July 2nd, 2023, when Mr. Fazliu visited Thaçi at the detention center. This is the basis for the group charge known as the Fazliu group in the indictment. Less than 2 weeks before that visit, on June 21st, 2023, the SPO informed the Case 6 accused that KLA insider Rustam Remy Mustafa would be called to testify in early July. An important prosecution witness, Mustafa was expected to testify for several days. Thaçi knew from Case 6 disclosures the precise details of Mustafa's anticipated testimony, including about his role as a zone commander in the war. 5 days after the SPO announced the upcoming witness order to the defense on 26 June 2023, Fazliu's son, Fahri Fazliu, reached out to Mustafa to set up a meeting between Mustafa, Fahri, and Fadil Fazliu. 3 days later, on the 29th of June, the three men met in Kosovo. Then, just a few days after that, Fadil Fazliu visited Thaçi at the detention center for about 2 hours. That visit was covertly audio recorded pursuant to judicial order. During that July visit, Thaçi focused on Rustam Mustafa's upcoming testimony. He referenced the witness by his nickname, Remy. Thaçi identified Mustafa's testimony as decisive to his case. And Mr. Thaçi explained how important it was for Mustafa to set a precedent for future witnesses by saying what Thaçi wanted him to say. Thaçi told Fazliu in detail how he wanted Mustafa to testify, what Mustafa must say, how he should say it, what his witness preparation session with the SPO would be like, and how he should handle it. That Mr. Mustafa could return to Kosovo as a, quote, hero or a, quote, disgrace, depending on how he performed. And then Thaçi directed Fazliu to deliver his instructions to Mustafa before his testimony, to, quote, get it done then. And the audio recording of this visit shows that Fazliu didn't just agree to do what Thaçi directed, he actively contributed his own ideas for what Mustafa must say in court, and he took concrete steps to implement the interference. They shared a common plan. Mr. Thaçi continued his pattern of obstructive conduct on October 6, 2023, when Mr. Kilaj, an uncharged co-perpetrator, Vlasnim Kresiu, visited Thaçi at the detention center as requested by Mr. Thaçi. The three men, the Kilaj group as charged in the indictment, met together at the detention center for several hours. Again, their conversation was recorded pursuant to judicial order. Thaçi used his visitors to target a specific Case 6 witness. This time, though, the object of interference was not a KLA insider, but instead an alleged crime-based victim in Case 6. Thaçi's motive, however, was the same. The victim witness, known as Witness 4 in this case, had previously implicated Thaçi in his unlawful mistreatment by members of the KLA. Witness 4 was originally scheduled to testify about these events in November 2023. Thaçi feared that Witness 4's testimony could severely damage him. And specifically, he feared that the witness would implicate Thaçi in what was done to him. Thaçi told Kilaj and Kresiu what needed to happen. Witness 4 needed to change a specific part of his prior testimony in order to undermine his prior identification of Thaçi as involved in his mistreatment. Kilaj and Kresiu made clear they understood and they agreed. And they actively engaged in the discussion of Witness 4 and other Case 6 witnesses throughout the visit. But during this visit, Thaçi left nothing to chance. He didn't just tell Kilaj and Kresiu what Witness 4 needed to say, he showed them, with Kilaj taking notes. Using printed copies of Witness 4's confidential prior statements that were disclosed to him in Case 6, Thaçi underlined, down to the part, page, and line number, exactly what the witness needed to change. And he didn't stop there. He was so concerned that his instructions for Witness 4 be followed to the letter, he actually gave them a copy of the critical pages of witness 4's statements to take from the detention center. This was not just a clear violation of the detention center rules, it was itself a crime. During this same visit, Thaçi also repeatedly revealed confidential information about multiple other prosecution witnesses, all in violation of court orders. For example, after describing the testimony of one protected witness whose evidence he disliked, Thaçi told Kilaj and Kilaj that the witness had, quote, tainted his family and, quote, ruined the honor of the family. Mr. Kilaj agreed, repeatedly telling Thaçi that the witness was, quote, an imbecile. After agreeing with Kilaj that this witness was, quote, completely stupid, Thaçi immediately revealed the identity of another protected witness, this time praising what he liked about the witness's testimony, calling him, quote, a real man, and then confirming where the witness was from. The very next day, the 7th of October, 2023, Mr. Thaçi continued his pattern of attempting to improperly influence Case 6. This time, his visitors were Mr. Smakaj and Artem Barami, an uncharged co-perpetrator in this case. This was Mr. Smakaj's second visit to Thaçi in less than a month and marked a continuation of his earlier visit on September 9th with the full Smakaj group as charged in the indictment. During both Smakaj visits, Thaçi revealed Case 6 information, including details about the testimony of multiple protected witnesses given in private session. Thaçi openly mocked victim witnesses, calling one a whore and ridiculing another for being disabled. Thaçi laughed as he did so, and his visitors laughed with him. But his main focus in both the September and October Smakaj visits was on one SPO witness in particular, Bislim Zerapi. Zerapi was an SPO witness who, like Mr. Mustafa, was anticipated to give evidence for several days about his role as a KLA insider. And just as with Mustafa during the July visit, Thaçi identified Zerapi by name and identified his testimony as, quote, decisive to his case. And then he homed in on what he wanted Zerapi to say and how he wanted him to say it. The evidence will show that Thaçi provided a detailed narrative for Zerapi to follow to help Thaçi's Case 6 defense. This narrative, in the form of a 10-page printed document, was seized from Mr. Smakaj's car just weeks after the 7 October visit, a fact I'll address in detail a bit later. As he did with Mustafa in July, Thaçi also focused on how Zerapi should testify, instructing that he should be concise and not let his, quote, tongue loose and not, quote, give opinions, and that the most emblematic sentence is, quote, I don't know, or, quote, I don't remember. Again, the instructions during the Smakaj visits had one common purpose, shared by all of the group members: minimize Thaçi's role in and accountability for the offenses charged in Case 6 to save him from conviction. And again, during both the September and October visits, Smakaj, along with other members of the group, willingly agreed to Thaçi's instructions and provided their own concrete additions to the instructions for how Zerapi should testify. Now, regarding Mr. Kuchi, in his case, Thaçi showed that he was so determined to interfere with Case 6 proceedings that he actually turned to a defense team member of another Case 6 accused to assist him. We see this in Kuchi's visit to Thaçi on the 3rd of September 2023, as charged in the indictment. On that day, Thaçi met with Thaçi alone in the detention center for 3 hours. By this time, Thaçi had been a member of Kadri Vaseli's defense team for nearly 2
Interpreters note the speaker is kindly requested to slow down for the purposes of interpretation. Thank you.
Mr. Hafetz, we just had a
I'm sorry.
note from the interpreters asking that you slow down a little bit.
Certainly,
please.
Your Honor. I'm surprised I made it this long. We see this in Thaçi's visit to Thaçi on the 3rd of September, 2023, as charged in the indictment. On that day, Thaçi met with Thaçi alone in the detention center for 3 hours. And by this time, Mr. Thaçi had been a member of Kadri Vaseli's defense team for nearly 2 years. And as Thaçi's decades-long friend, who also had unfettered access to all disclosed witness information in Case 6, Mr. Thaçi was perfectly positioned to be another tool of witness interference and contempt of court. The September visit shows Thaçi engaging in the same witness targeting as the other examples I just discussed. After first talking about everyday topics, Thaçi and Thaçi started whispering about what really mattered to Thaçi: getting Case 6 witnesses to testify the way he wanted. He gave Thaçi detailed instructions for at least 3 different witnesses. 2 were KLA insiders, including, again, Bislam Zarapi. And the 3rd was another crime-based witness who was anticipated to testify about his alleged unlawful mistreatment by the KLA. As with each of the other co-accused in this case, Thaçi willingly agreed to execute Thaçi's interference orders and provided his own advice on what the witnesses needed to say to best help Thaçi's case. To make sure that there was no confusion and that his instructions were followed properly, Thaçi told Thaçi to write down what Thaçi was telling him. Thaçi agreed. And in the case of the victim witness, known as Witness 6 in this case, Thaçi insisted that Mr. Thaçi needed to act urgently because the witness was expected to testify soon. Thaçi was so concerned about this timing that he told Thaçi to start the work on the witness as soon as he landed back in Kosovo at midnight on September 6th. Thaçi agreed, and his phone records show that he did as he was told. In addition to committing contempt of court by agreeing to unlawfully contact witnesses for Thaçi, Thaçi is also charged with a separate contempt count for contacting Rustam Mustafa in April 2023, just as Case 6 was starting. This contact was a direct violation of the Case 6 witness contact protocol. In his message, Thaçi passed on to Mustafa the congratulations of an unnamed person for his, quote, clear ideas about the country and the war, end quote. Ideas which notably align with the interference instructions Thaçi issued to Mr. Fazliu during their July visit. Your Honor, Thaçi's attempts to influence and interfere with witness testimony were not limited to the 5 recorded visits I just described. As charged in the indictment and shown by the evidence, Mr. Thaçi used multiple other visits to reveal confidential information and to issue witness interference instructions. The motive for the interference was always the same: to get witnesses to change prior statements or otherwise shape their testimony to help Thaçi's case. All that ever changed was the day on the calendar, the accomplice in the room, and the specific witness to be targeted. So the question is, how is the prosecution going to prove all of this beyond a reasonable doubt? And the answer is with overwhelming evidence, nearly all of which has already either been admitted in this case or judicially noticed. This evidence will include the judicially authorized audio recordings themselves of Thaçi's visits with his co-accused, as well as with other visitors on other days, where he focused on targeting SPO witnesses for interference and revealing confidential witness information. The recordings reveal, in Thaçi's and the accused's own words, often whispered, their utter contempt for the witnesses, for the court, and for the rule of law. The evidence will also include KSC detention records confirming the presence of each accused in each visit, recorded detention center phone calls, KSC court orders, decisions, and regulations showing the rules and orders Thaçi and his co-accused violated, and the timing of certain key events in Case 6 that give context to the attempted obstruction. Will include Case 6 court records as they were disclosed to Thaçi in Case 6, which Thaçi then used to target specific witnesses and to reveal their confidential information in violation of court orders. Physical evidence collected from the accused pursuant to judicially authorized seizures, including documents that were printed from the detention center, then used by Thaçi and his co-accused to target witnesses during their visits, and then seized from his co-accused's residences in Kosovo. It will include evidence collected from seized mobile phones and other electronic devices, including communication records directly corroborating what was discussed during Thaçi's visits. It will include records collected from the KSC's detention center computer and printing systems used by Thaçi, including evidence showing the printing of certain documents used to target witnesses for interference. And finally, evidence and expert testimony further showing that certain witness-related documents seized from the accused were in fact printed by the only detention center printer used for detainee printing and available to Mr. Thaçi. Your Honor, this evidence is mutually corroborating and reinforcing, and it shows, beyond any reasonable doubt, that the accused committed each of the charged offenses. So let's talk a little bit more about the details of how the evidence fits together. There are now in evidence 9 audio-recorded Thaçi Detention Center visits. Just a word about those recordings. As noted in publicly available filings, and as I said already, the audio recordings were obtained pursuant to judicial order. The recording authorizations were limited to just a few months of Thaçi's detention and were subject to judicial oversight. That Mr. Thaçi is the man targeting witnesses and revealing their protected information on those recordings is unmistakable and irrefutable. he is clearly identifiable, not just by his voice, which was captured across hours of recordings, but by the content of what he says, including numerous facts specific to him. His is also the same voice heard consistently during each of the recorded jail calls in evidence, all of which were maintained by the registry pursuant to KSC regulation. Mr. Thaçi is also identifiable by the common pattern of witness interference instructions he ordered and by the confidential witness information he revealed across multiple visits. It's the same content. Instructions and information that then matches facts collected outside of the visit rooms. That the co-accused here are the people Thaçi's talking to on the visit recordings is also unmistakable. The fact that each of these men visited Thaçi on the day of the recording is documented by multiple registry records, including detention center logs showing their physical presence at the detention center on the relevant date and their own signed visitor applications. And then in the audio recordings themselves, Thaçi addresses the men by name. And they all reveal facts about themselves that are easily matched to external evidence, including their own phone records. Now, parts of the recordings are more difficult to hear than others. Your Honor will hear this for himself. This was by design. It was intentional. Thaçi and his co-accused knew. They knew from the KSC regulations they all received, and they knew from just physically being there that everything said during these visits was supposed to be audible to a detention center officer outside the visit room. At times, when it did not get in the way of their scheming, Thaçi and his co-accused complied with the rules. Indeed, they often spoke in normal voices and normal volume, usually to talk about politics or give updates on family life or share opinions about how Thaçi's legal team was performing in Case 6. But then, when it mattered most, when he wanted to talk about the work of interfering with witnesses, when he wanted to provide his detailed instructions for his visitors to carry out, Thaçi shifted gears. He dropped his voice to a whisper, and his co-accused followed his lead. You can hear this throughout the admitted recordings in this case. It was not an accident, it was the point. This is clear even from this brief audio excerpt from the July Fazliou visit, which we will play now. The recording and the transcripts for this excerpt are admitted SPO exhibits P105, ET, and AT. What you will hear is that after Thaçi finished with the pleasantries and was now ready to tell Fazliou what to do about Rustam Mustafa and his upcoming testimony, his voice changed. Thaçi started whispering to conceal his instructions and avoid detection. And the volume of his whispering got lower and lower the more detailed his instructions became. The clip is just under 3 minutes long, and we'll play it now.
Askeri den cüzdan evi oldu.
Що шобро?
Bir masnesi
Коли повер?
ne badin tijd, polisti. Чи кофе την τζάρτα τζάρς, δεν μπορώ.
Хорошо.
Що це не шкуби по?
Кожа він дивдовшт.
Po të kam drejt. Është kene përsita jo, ata bosin e përsita, ata do thonë kryta, se nuk ne. Thash, vetë
Nësë më në nda, thaj, kur ki nuk?
Nesa. Ke gjëtë me nësi s'kime të gato.
Se besoj që më në...
Jo, po se me gjashtin ja me katët, do thënë.
Jo, të martën në ta.
Po të martën më nuk po dikush ta me në gazet ke me gjashtin. Po më se kanë rrugë.
Shkorte. Pas filozofa.
Jashtë po, thaj, si s'ka.
Jo, po, jo. Martën mës.
Jo, tha ku me thonë për lapë, i mëne. E që të dhujti?
Po, edhe këta shumë ato kushe.
Po, qështë e ka, qështë e ka.
Ato, këta se janë shumë ato.
Tu s'kam punë, s'm tërëso për ta iq.
Se s'kam ditë me një
Këtë i këmë vetë, qartë. Po.
Edhe, adem dhe mo që morë këmë posë.
Po, qështë, na, thash, hani, më nëjë kur të vitash, bëjmë vlave, një tha kuri, thash, si të veshta, hajde për këmë.
Edhe, frosin.
Jo, të rëmë kafe, pika, ja, është eqë, asë njerë. Se kam gjani fari, thimet të telefonet, dhe majtë ku pim kafe.
Se është jeti. Se në tytet më herët e kapi më këne edhe thot.
Se di, këdi e ko, mëse që koj.
Tytet më herët e të ashtimin e thjeve, lezoj të tanga këtu se i pas, a kime i ndryshone, që i ka bërë e zërë të rëshajtë, se në salë këtë ishte e bërë.
Më në ndryshone, po që se da?
Po që janë më se letë, ta planifikojnë dy motorë me marë pytje. Dy motorë pa shiti ka se letë. Se një shkort, jo, po, jo, pi.
Me përsi për keqë të që e gjiri,
Ka, që atë e unë një ka. Jo këta,
por pjesën që këne që e ka një kon ti.
Po, dhe ka, këta s'ka po. E ka mirë dhe këra, po, mundet me shritë se gatë, shkurti, po, jo...
Të lodhë në tha, që është të lodhë.
Të
lodhë në tha.
Shkurtojt, mos i lesit.
Tash mas t'i nga kënë të kushtit, që jo nësë, prapë. Edhe prurë i lartë dhe vaj, ka më thonë.
In just this short example, you see the elements of the attempted obstruction charged in the indictment. There are Thaçi's clear instructions for Fazliu to give Mustafa for how to testify to minimize Thaçi's responsibility and culpability. There's Fazliu providing his own input for what Mustafa should say and reporting to Thaçi that he has already started playing the middleman for messages between Thaçi and Mustafa, using his son Fari to facilitate this. And here's the point. While the conduct captured in each charged visit recording is sufficient to prove the charges arising from that visit, Your Honor will not have to rely on the recordings and the transcripts alone to convict. Because for each charge, there is independent evidence from outside the recordings that both corroborates the content of the transcripts and reinforces the accused's guilt. Let's take the excerpt we just listened to. Detention records confirm Mr. Fazliu's visit on July 2nd. In addition to Thaçi and Fazliu actually naming Remy when they start discussing him, KSC court records disclosed to Thaçi in Case 6 contain multiple identifying factors that prove Thaçi was indeed targeting Rustam Mustafa for interference on July 2nd. Those records are judicially noticed. Text messages and other seized phone records show that the details of what Thaçi and Fazliu discussed, planned, and agreed during their recorded July meeting inside the detention center is exactly what happened in the world outside. For example, Fazliu reported to Thaçi that he had already met with Mustafa at the Route 66 diner on the Thursday immediately before Fazliu left Kosovo to visit Mr. Thaçi. That was right here in the excerpt we just played. Text messages seized from Mr. Mustafa's cell phone confirm this. First, you see here in SPO exhibit bearing SPO E 398224 that on June 26, 2023, Fari Fazliu first contacted Mustafa on his father Fadil's behalf and tried to set up a meeting. As the messages show, the meeting didn't happen on the 26th because Mustafa was out of town. Mr. Mustafa's text messages then show that 3 days later, on Thursday, like they said, on June 29th, Fari succeeded in setting up the meeting with Mustafa at Route 66 in Pristina, just as Fadil Fazliu reported to Thaçi during their July visit. And Your Honor, I'd ask your indulgence to continue just 2 minutes over and I can finish this section. Thank you. Fazliu also told Thaçi that he and Mustafa had agreed to meet again after Fazliu returned from The Hague, with Fazliu ready and willing to transmit any messages for Mustafa from the detention center. Fazliu also told Thaçi he would use his own son, Fari, to set up this next meeting with Mustafa, and that Fazliu would fly home from The Hague to have this meeting with Mustafa the very next day, July 3rd. Thaçi and Fazliu discussed each of these concrete plans in the excerpt we just listened to, as seen here, and then here, where Fazliu confirmed he would travel back to Kosovo the next day to meet with Mustafa, and then here, where Fazliu confirmed he would meet with Mustafa as soon as he was back. And then here, where Fazliu confirmed again he would use his son, Fari, to set up the meeting with Mustafa. Again, Your Honor, the evidence collected from outside the detention center matches. First, Fazliu's phone records seen here at SPO Exhibit P120 show that Fazliu indeed returned to Kosovo on July 3rd, just as he promised Thaçi he would. Second, text messages seized from Rustam Mustafa's phone, seen here, show that just hours after Fazliu landed back in Kosovo on July 3rd, this time armed with Thaçi's detailed interference instructions, he had his son, Fari, arrange another meeting with Mustafa. There is nothing wrong, by the way, the evidence will show, with Mr. Mustafa, with Fadil's phone. He knows how to use a phone. Finally, travel records show that on Tuesday, July 4th, just 1 day after he met the Fazlius, Mustafa flew to The Hague to prepare for his testimony exactly as Thaçi and Fazliu had discussed. Your Honor, this is how the evidence in this case works. Thaçi's and his co-accused attempts to hide and conceal their conduct failed. They failed because the evidence collected from outside the walls of the detention center and its visit rooms consistently reinforces and corroborates what Thaçi and his co-accused planned, whispered, and agreed inside the visit rooms. Your Honor, I have a little bit left, but I think now would be the good time to take a break.
Thank you, Mr. Hafetz. We'll take a break until 12 noon sharp, please.
All rise. All rise. Please be seated.
Just a brief scheduling note before we recommence. The registry has very kindly facilitated shortening the lunch hour. So we will take the lunch from 1:30 to 2:30 and then recommence then and finish at 4 p.m. Mr. Hafetz, you have the floor.
Thank you, Your Honor. Let's take another example of how the evidence works in this case. I spoke a few minutes ago about the Kilaj group visit on October 6th, 2023. In that visit, Mr. Thaçi targeted witness 4 for interference and used the witness's prior statements as an instruction manual to tell Mr. Kilaj and Mr. Kreitzu exactly what needed to be done, including precisely which part of witness 4's testimony needed to change and how. The recording of this visit shows exactly how Thaçi and his co-accused operated. At the beginning of the visit, Thaçi, Kilaj, and Kreitzu speak at full volume. They speak normally to exchange greetings and discuss everyday life. You can hear an example of that in this very brief clip from the start of the visit, which is found at SPO P109 and ET and AT, already admitted. We'll now play the clip in full. It's about 20 seconds long. What you just heard is what happens when Thaçi and his visitors have no reason to hide what they're saying. Regular tones to discuss regular life and name each other, by the way. But later in the visit, when the time came to focus on interfering with witness 4, Thaçi and his visitors' voices changed, and the whispering began. The next 3-minute clip from the visit demonstrates this. We're going to play the clip now and pause at 25 seconds in. Despite the whispering, and despite the insistence on not naming the person they're talking about, the evidence will show that the men are discussing witness 4, a protected and confidential witness in case 6. And in particular, they're discussing a specific part of the witness's anticipated testimony that Thaçi wanted to influence. We'll now continue playing the clip until 52 seconds in. Here, Mr. Thaçi is describing the established Case 6 procedure of witnesses traveling to The Hague and reviewing their prior statements shortly before their testimony. Mr. Kilaj offered to take the confidential witness 4 statements that Thaçi is talking about and referring to and bring them to witness 4 to convey Thaçi's instructions. But Mr. Thaçi knows better. As he explained to Kilaj, there was no need for Kilaj to take all of the pages of witness 4's prior statements from the detention center, because the SPO will give the witness his full statements to review when he comes. Thaçi then explains that he has a more specific plan and instructions in mind. And we'll now play the clip until 1 minute and 27 seconds. Even in his whispered voice, Thaçi's command is clear. Witness 4 has to, quote, correct, which means change to Thaçi's advantage, his prior evidence. Specifically, Part 6, page 7 of his confidential SPO interview. And the witness needed to make that change here in The Hague, in his SPO witness preparation session, before he entered the courtroom to take the witness stand. Thaçi ordered that this is the page and the part that his visitors needed to take with them to get the job done. And then, to make sure there was no doubt about his orders, no room for mistake, Thaçi made his instructions even more explicit. We'll play the clip until 2 minutes and 7. Part 6, page 7, down to the specific line. Your Honor is the ultimate fact finder, but you can hear clearly the sound of paper on the recording. Witness 4 must be told to make this part of his prior evidence better. Better for Mr. Thaçi. And in the final portion of the excerpt, Thaçi drove home his command. We'll now play the clip until the end. Thaçi even predicts what the judges are going to ask the witness. Now, the last part of this recording excerpt is unquestionably more difficult to hear because of Thaçi's very low whispering. But the effort to cover up what he was saying still failed. And that is because the evidence will show that the specific parts of witness 4's prior statements that Thaçi repeatedly targeted, part 6, page 7, were the exact parts where the witness was asked about Thaçi's involvement in his alleged mistreatment by KLA members. In other words, what Thaçi wanted at part 6, page 7, was to eliminate evidence of Thaçi's personal involvement in the witness's alleged mistreatment. And again, it is evidence collected outside the detention center that proves this beyond a reasonable doubt. On November 2nd, 2023, less than 1 month after Kilaj and Kretsu's visit to Thaçi, the SPO conducted a judicially authorized search of Mr. Kilaj's residence. During that search, the SPO seized torn up pieces of paper from inside a trash bag by Kilaj's front door. You see that bag here. SPO Exhibit P123. As it was found, stuffed with torn pieces of paper. Forensic experts reconstructed those torn pieces of paper. And the results show that Kilaj had torn up and trashed not random pieces of paper, but the 2 confidential prior statements of witness 4. One of those torn pages is seen right here at SPO Exhibit P3. This, Your Honor, is part 6, page 7 of witness 4's prior statement to the SPO. It's blurred here in court because it remains confidential. The full version of witness 4's SPO statement was disclosed to Mr. Thaçi in case 6 before the Kilaj group visit. He had it. And the part of the document, as seized from Kilaj, matches exactly the same part and same page number that he ordered must change during that October visit. The torn up document seized from Kilaj even has highlighting and handwriting on the precise parts of the page that Thaçi repeatedly demanded that the witness had to change before testifying. This includes, Your Honor, a hand-drawn box around the question and answers starting at line 9 of part 6, page 7. That's the part about the witness's prior identification of Mr. Thaçi. And that is not all, because the SPO also received, by judicial order, records from the detention center computer and printer used by Mr. Thaçi. All of these items were reviewed by an independent counsel before being provided to the SPO. none of these records has any legal privilege. And what this evidence shows is that Thaçi printed this same confidential part of witness 4's statement just 2 days before he used it during his visit with Mr. Kilaj and Mr. Krasiu. You see this before you in Exhibit P128. The evidence will also show that Thaçi printed several other witness 4 related documents shortly before the 6th October visit with Kilaj and Krasiu, including another document found torn up in Kilaj's trash. The computer records for those documents are here at SPOP 133. In other words, Your Honor, the evidence comes together in this case to show that even Thaçi's faint whispering on the audio recordings is backed up and corroborated by overwhelming physical and electronic evidence. And what all of this evidence shows is the organization, the planning, and the concrete steps the accused took in their attempts to obstruct the proceedings and interfere with witness testimony for Mr. Thaçi's benefit. I'm going to take one more example to illustrate how this works. As pled in the indictment, the Smakaj group charges in this case arise from 2 visits, one in September and one in October 2023. During both visits, Thaçi repeatedly targeted Bislim Zerapi for interference. Talked about that a moment ago. This included Thaçi's lengthy recitation of specific points for Mr. Zerapi to make in order to minimize Thaçi's role and accountability. This included that the general staff was made of only 6 individuals until November 1998, excluding Mr. Thaçi, that Thaçi went abroad between November 98 and March 1999, and that generally the focus should be on the zone commanders at Adam Damaci. During the 7 October visit, Thaçi and his visitors used an additional tactic on top of his usual whispering to conceal their discussion of witness instructions. This time, just before he started whispering to Smakaj about Zerapi, Thaçi told Artem Barami to, quote, speak louder in order to cover up Thaçi's whispering. Thaçi then began whispering to Mr. Smakaj about Bislim Zerapi. Smakaj reported to Thaçi that he had already been in contact with Zerapi and that Zerapi sent, quote, greetings. That is all here in this brief clip from SPO P110. The clip is about 1 minute long, and we'll play it now.
Det man sviter till det först. Så jag kan först. Får det man gör med det. Ja, lätt. Man sviter vågar det först. Då får det chatt man där och så för det man Кто? Ой, вот вот чуть-чуть. Ждёт это. Папа. En går över vågen att passa för en night peak. Det diktar ju oss någon vilket är pika pressing.
Here again, the evidence collected outside the detention center matches what was whispered inside it. Specifically, SPO exhibit bearing ERN 125731, seen here, contains records seized from Mr. Smakaj's mobile phone. And the records show that on the 2nd and 3rd of October 2023, Smakaj and Zarapi were in contact, just as Smakaj reported to Thaçi a few days later. And in this next brief excerpt from the 7 October visit, just as Thaçi did during the Kilaj group visit, he used documents to make sure his interference instructions were followed. We'll now play the final short clip that I'm going to play today, which is, again, from SPO Exhibit P110. Now, just 3 weeks after Smakaj and Thaçi discussed exchanging papers, with Thaçi telling him, "You keep these ones," one of the documents the men were discussing when targeting Bislam Zarapi for interference was found. The document was seized from Mr. Smakaj's car. The first 2 pages of the document are seen here at SPO Exhibit P125. That's admitted. The document has highlighting and annotations, both added by hand. It contains a narrative diminishing the level of KLA organization and Thaçi's leadership role in the KLA, while shifting responsibility to other actors to minimize and eliminate Mr. Thaçi's culpability for the crimes charged in Case 6. The narrative seized from Smakaj's car was intended to influence the anticipated testimony of several KLA insider witnesses targeted across recorded visits, including Bislam Zarapi. This is clear, Your Honor, from, among other things, the multiple handwritten B's before parts of the narrative that relate specifically to Mr. Zarapi's anticipated testimony. It's also clear from the fact that several of the parts of the document match Thaçi's oral instructions for, quote, Biza, meaning Bislam Zarapi, during the recorded 7 October visit. You can see this, for example, by comparing the transcript of that visit with the text of the seized Smakaj document, as seen here at SPO Exhibits P110, AT and ET, and SPO Exhibit P125. Just this one page of the Smakaj document excerpted here contains multiple matches with Thaçi's October 7 instructions to Smakaj on how Mr. Zarapi should testify, including that the general staff was composed of only 6 people, 3 members in Kosovo, including 2 literature students, and 3 members who were abroad. There are multiple other matches and evidence, several of them verbatim. The evidence will also show that that same seized Smakaj document, minus the handwriting and highlighting, was found on Mr. Thaçi's detention center computer under the file name Per Avocatet, meaning 4 lawyers. The same file containing that Smakaj document was printed at the detention center just hours before Smakaj and Baramai visited Thaçi on the 7th of October. You see the printing record here which is from SPO Exhibit P128. And to be clear, Mr. Smakaj is not and has never been a Case 6 lawyer or defense team member for Mr. Thaçi. Together, this evidence shows that Thaçi was organized and prepared for the 7 October visit so that he could get and target Mr. Zerapi's testimony in line with what he wanted with the Smakaj group. And finally, the evidence will also show that the printer used to print that Smakaj document seized from Mr. Smakaj's car was the same printer used to print the confidential statements that Thaçi used to target witness 4 on October 6th. The same witness 4 statements seized from Mr. Kilaj's trash after Mr. Kilaj tore them into pieces. From Exhibit P128. The evidence in this case, Your Honor, is overwhelming, and it is mutually reinforcing. It fits together because, as charged, Mr. Thaçi was the leader and organizer of a persistent series of attempts to obstruct and interfere with his trial in Case 6. And together, the evidence will prove that Mr. Thaçi, Mr. Kilaj, Mr. Smakaj, Mr. Fazliu, and Mr. Kuchi are each guilty, beyond any reasonable doubt, of the offenses charged against them. My colleagues, Mr. Hicks and Ms. O'Connell, will now briefly address Your Honor on the applicable law. Thank you.
Good afternoon again, Your Honor, colleagues in the courtroom. You've now heard about the general backdrop of KSC proceedings, particularly why the rule of law must be vigorously upheld in the face of pervasive witness interference. Further, you heard what this case is about. That is, how Mr. Thaçi chose people close to him to attempt to interfere with Case 6 witnesses for one reason, to help him avoid conviction in that case. And you've seen and heard a summary of just some of the overlapping and reinforcing evidence, including the accused's own words inside the detention center and the corroborating evidence collected outside of it. In this last section of our opening statement, Ms. O'Connell and I will briefly outline the crimes charged in the indictment. The offenses and related modes of liability are specifically tailored to the individual actions and circumstances of each of the accused. Nonetheless, all charges fall under 3 categories of offenses. Firstly, attempted obstruction of official persons in performing official duties. Secondly, violation of the secrecy of proceedings. Thirdly, contempt of court. 4 of the accused, Thaçi, Smakaj, Kilaj, and Fazliu, have been charged with attempted obstruction. Thaçi is the only accused who is also charged with violating the secrecy of proceedings. Finally, all 5 of the accused have been charged with contempt of court. I will start with attempted obstruction. This offense arises from Article 401, subparagraph 2 of the Kosovo Criminal Code, which holds that anyone participating in a group of persons which, by common action, obstructs or attempts to obstruct an official person in performing official duties shall be punished. In this case, the foundation of the attempted obstruction charges under Article 401(2) arise from 3 distinct groups. As has already been described, the Fazliu group, including Thaçi as the leader, Fazliu and his son Fari. The Smakaj group, including Thaçi as the leader, Smakaj, Blerim Shala, and Artan Barami. Lastly, the Kilaj group, again including Thaçi as the leader, Kilaj, and Vlasnim Krețiu. Each group carries 1 charge per accused as they all undertook common action focused on obstructing Case 6 by attempting to interfere with SPO witness testimony. There are two further provisions under Article 401 relevant to the charges in this case. Those are subparagraphs 3 and 5. These two provisions are focused on aspects which enhance or aggravate the attempted obstruction of a charged person. Specifically, Article 401(3) states that a leader or organizer of a group who commits attempted obstruction shall be punishable by imprisonment of 1 to 5 years. This provision applies to Thaçi, and he is charged with 1 count for each of the 3 groups he participated in and led. Additionally, and per Article 401(5), when attempted obstruction is committed against a judge, a prosecutor, an official of a court, prosecution officer, or a person authorized by the court and prosecution office, during the exercise of their official functions, the perpetrator shall be punished by imprisonment of 1 to 5 years. This aggravating factor applies to each of the charged members of the 3 groups, Thaçi, Smakaj, Kilaj, and Fazliu, because their actions were intended to compromise the KSC and the SPO's ability to effectively investigate and prosecute crimes, particularly securing relevant and truthful witness evidence. The bottom line as to these respective charges, all of which include an enhanced sentencing component, is that a conviction on any 1 count for any of these 4 accused carries a minimum sentence of 1 year and a maximum sentence of 5 years. That the actions of the 3 charged groups attempted to obstruct an official person in performing official duties is plain. As affirmed in the pretrial confirmation decision in this case, attempts to unlawfully influence the testimony of SPO witnesses could result in compromised evidence that may no longer be used at trial. They may lead to the impeachment of witnesses, and they may affect the integrity of KSC proceedings. All of these outcomes obstruct the work of SPO staff, including investigators and prosecutors, as well as KSC judges. The steps taken by the group members, which are established by the evidence in this case, were substantial, they were concrete, and they were specific. They do not need to have actually succeeded in contacting and influencing the witnesses. That's not what the accused are charged with here. What they are charged with is attempt, and those efforts are criminal. That is the law which seeks to safeguard the effective functioning of the legal system by way of the unimpeded performance of official duties from attempts to undermine the course of justice. In short, Article 401.
The interpreters kindly ask the speaker to slow down, please.
In the same manner as obstruction, which is fully realized, because this is precisely what was intended when the law was written. Nonetheless, it is important to highlight that there were contacts between some group members and targeted witnesses, both before and after the charged visits. The reasonable inference, which is not necessary to establish guilt for attempted obstruction, is that these contacts were in fact intended to implement the common plan. My colleague has already given you examples of these. The totality of the evidence shows that the members of the Fazliu, Smakaj, and Kilaj groups, all led by Thaçi, intentionally participated in a group focused on the attempted obstruction of targeted Case 6 witnesses. Indeed, There can be no doubt that the accused knew what they were doing, and they knew it was a crime. For example, look to the explicit caution that Thaçi delivered to Fazliu to use an intermediary to contact Rustam Mustafa and Fazliu's compliance with that direction. Look to the 6 October visit when Thaçi advised Kilaj and Krețiu that, if not careful, quote, they will bring you in here with me, unquote. With Kilaj responding, quote, it does not matter, I can stay for a couple of years, just a couple of years, unquote. Look to the 7 October visit when Berami read detention regulations out loud and in Smakaj's presence, establishing that visitors are not allowed to exchange items with detainees while they waited for Thaçi to arrive. Ultimately, the group members all undertook acts which contributed to the goal of impeding and hindering KSC and SPO officials in proceedings before this court. The legal requirements for the charges of attempted obstruction are fulfilled for Thaçi, Fazliu, Smakaj, and Kilaj. This concludes this section on attempted obstruction, and Ms. O'Connell will now address you on the remaining charges.
Good afternoon, Your Honor and colleagues in the courtroom. I'm Claire O'Connell on behalf of the SPO. Moving on to the offense of violating the secrecy of proceedings pursuant to Articles 392.1 and 392.2 of the KCC. Only Thaçi is charged with this offense and counts 4, 5, 6, and 7 of the indictment. Under Article 392.1 of the KCC, someone who, without authorization, provides information disclosed in any official proceeding which must not be revealed according to law, or was declared secret by the court or a competent authority, shall be punished. Alternatively, 392.2 of the KCC provides that a person who, without authorization, reveals information on the identity or personal data of a protected person under protection in criminal proceedings shall be punished. The unlawful revelation of information may include displaying or distributing material in original or copied form, citing, describing, or referring to content of the material, and making the material available to others so as to allow them to read or copy the material or its contents. The 4 counts of violation of secrecy of proceedings that Thaçi is charged with arise from the disclosure of confidential information and the identity and personal data of a protected person, which must not be revealed and which was not authorized to group members during the 2nd July, 9th September, 6th October, and 7th October group visits. This information revealed by Thaçi during the group visits was classified as confidential in KSC filings. Such filings include the SPO witness lists in Case 6 and protective measures decisions issued by the Case 6 trial panel. Additionally, Thaçi received and wrongfully revealed the contents of confidential evidence as disclosed by the SPO during the group visits. As has already been discussed earlier today, confidential information that was revealed by Thaçi included the names and anticipated testimony of witnesses in Case 6, the timing of their appearance in court, details of evidence provided in private session before the KSC,
personal biographical information of witnesses which were not public, and more. Thaçi was not authorized by the SBO or the KSC legal framework to reveal any secret information to his visitors. Full stop. That Thaçi did so with the aim of obstructing witness testimony in Case 6 to minimize his criminal responsibility in that proceeding serves as an aggravating factor. The violations of secrecy of the Case 6 proceedings were not accidental or inadvertent slips of the tongue. Rather, Thaçi's revelations were repeated and intentional, and in full knowledge of the illegality of his actions. As a party to the Case 6 proceedings, Thaçi was well aware of the obligation incumbent upon him, or to treat confidential material and the status of protected witnesses with due care and restraint. Thaçi was reminded of that obligation not only through the filings and classification of evidence he received, but also, for example, at the start of the SPO's evidence in Case 6 on 11 April 2023, when the presiding judge underscored this obligation and stated as follows: "The panel reminds the parties and the participants of their duty to observe at all times throughout the presentation of evidence all protective measures in place." He continued, "In addition, the panel notes that the list of SPO witnesses is currently classified as confidential. Therefore, the fact that an individual is a prospective SPO witness is confidential, even when such an individual is not a protected witness." And yet, despite this clear legal framework prohibiting the revelation of confidential information, Thaçi repeatedly and intentionally violated the secrecy of the Case 6 proceedings. Thaçi's conduct thus fulfills the legal requirements for the 3 counts charged under Article 392(1) of the KCC, and for 1 count charged under 392(2). Finally, contempt of court. All 5 of the accused are charged with contempt of court. Thaçi under counts 8 to 11, Smakaj under count 13, Kilaj under count 15, Fazliu under count 17, and Kuchi under counts 18 to 19. Article 393 of the KCC provides that whoever fails to obey any final order, ruling, decision, or judgment of a court shall be punished. For Thaçi and Kuchi, the contempt charges in this case arise primarily from the Case 6 protocol, which is a decision issued by the Case 6 trial panel concerning the handling of confidential information by parties and participants in that case. At all relevant times, Thaçi was an accused in Case 6, while Kuchi was a member of the Vaseli defense team. Notably, this protocol applied to all contacts with the witnesses of an opposing party, including after their testimony. As the protocol was upheld on appeal, it was unquestionably a final decision. Relevant to the contempt charges, the Case 6 protocol prohibited a party or participant in Case 6 from providing confidential information to third parties unless strictly necessary and subject to strict conditions, revealing to third parties the involvement of any protected witness with the KSC or SPO, and contacting the opposing party's witnesses outside of the framework implemented therein. As to Thaçi, he committed contempt of court as charged in counts 8, 10, and 11 by violating the Case 6 protocol. He did so by tasking his co-accused with contacting witnesses outside of the protocol and by repeatedly revealing confidential information about witnesses to his visitors during the 2nd July, 9th September, 6th October, and 7th October visits. This pattern of disobeying the K6 protocol was not necessary for the presentation of and preparation of Thaçi's case. Rather, the contempt of court was part of the accused scheme to interfere with K6, including Thaçi's clear and repeated instructions to group members to contact witnesses, using them as intermediaries to attempt obstruction. Similarly, as charged in Count 9, Thaçi agreed with Kuchi to commit contempt when, at Thaçi's direction, they agreed that Kuchi should contact SPO witnesses outside of the K6 protocol, and Kuchi took substantial steps to implement that agreement. As with all of the crimes charged, Thaçi's intent is clear from both his actions and the manner in which he undertook those actions. Most notably, the pervasive use of whispering and hushed tones when he and others were discussing confidential information in direct violation of the K6 protocol. Contemptuous intent is also evident in the effort to reach out to witnesses secretively, in clear violation of the K6 protocol, with the hope of avoiding detection. Simultaneously, and under Count 18, Kuchi agreed with Thaçi to commit contempt by way of their agreement to contact SPO witnesses outside of the K6 protocol. This agreement includes substantial acts to implement, such as Kuchi's initiative to immediately meet with at least one targeted witness upon his return to Kosovo during the 3 September visit, following the 3 September visit. Further, Kuchi agreed to write down Thaçi's instructions during their visit, provided his own suggestions on what targeted K6 witnesses should say, and even indicated that he had already spoken to one or more witnesses. Again, as with all of the crimes charged, the efforts of Kuchi and Thaçi to obscure their agreement to commit contempt by whispering during the 3rd September visit further establishes that they knew their conduct was prohibited by the K6 protocol. Similarly, Kuchi committed contempt of court due to his clear and intentional violation of the K6 protocol, as charged in Count 19. More specifically, Kuchi's direct contact with a K6 witness on 12th April 2023 in violation of the K6 protocol results in the commission of contempt. This contact is clear and indisputable. Further, the fact that Kuchi, a trained lawyer and, at the relevant time, K6 defense team member, knew that this conduct was in violation of the K6 protocol cannot reasonably be disputed. Finally, we come to counts 13, 15, and 17 of the indictment, which charge Smakaj, Kilaj, and Fazliu, respectively, with contempt of court. The mode of liability for these charges is assistance, and that these three accused provided assistance to Thaçi in his commission of contempt. Specific to this notion, Article 33 of the KCC provides that assistance in committing a criminal offense includes creating conditions or removing impediments to the commission of a criminal offense. Importantly, Smakaj, Kilaj, and Fazliu all signed a visitor undertaking in which they agreed not to disclose any information that could compromise the administration of justice or otherwise undermine the authority and mandate of the KSC. This fact establishes that they had a keen awareness of the type of conduct which is prohibited at the KSE Detention Center. Consequently, and while Smakaj, Kilaj, and Fazliu were not parties or participants in Case 6, they unquestionably knew that they could not trade in confidential information about SPO witnesses. Indeed, their awareness that their conduct was unlawful is clear from their behavior during the respective visits, particularly employing whispers and low voices when the discussion pertained to confidential Case 6 witnesses. Another such example of such awareness is Kilaj's tearing up portions of confidential witness statements, material which was subject to and protected by the Case 6 protocol that he received from Thaçi during the 6th October visit in the hopes of avoiding detection. During his SBO interview, Kilaj admitted to having this material in his possession, lied about how he obtained it, and conceded that it was material he should not have in his possession, as it was, quote, not a matter or an issue that I should be looking into, end quote. These are all clear indications of his intent to cover up his assistance of Thaçi's contempt. All of these factors establish that Smakaj, Kilaj, and Fazliu appreciated that they were prohibited from acting as an intermediary between Thaçi and Case 6 witnesses. Broadly speaking, Smakaj, Kilaj, and Fazliu's active engagement during their respective visits to Thaçi, including providing advice, offering feedback and moral support, agreeing to write down exactly what Thaçi told them so that his interference instructions could be delivered clearly, and taking possession of confidential documents, created conditions and removed impediments to Thaçi's violation of the Case 6 protocol and the related commission of contempt. Importantly, the person providing assistance need not intend the commission of contempt. They must simply provide assistance to the perpetrator knowingly and intentionally. Consequently, the acts and conduct of Smakaj, Kilaj, and Fazliu in the respective visits enabled, encouraged, and facilitated Thaçi's commission of contempt of court. They are therefore guilty of assisting the commission of this offense. The SBO's evidence in this case is compelling and overwhelming, and reflects repeated efforts by the accused that are the textbook definition of obstruction. Ultimately, there are no valid defenses to the criminal conduct of the accused. The evidence will show that the accused committed the crimes charged in the indictment repeatedly, knowingly, and intentionally. After all the evidence is presented, we will return to your honor and ask that the accused be held responsible for their actions in accordance with the law. Thank you for your attention, Your Honor. This concludes the SPO's opening statement.
Thank you, Ms. O'Connell. Mr. Rees, I understand that there will be an opening statement on behalf of Mr. Smakaj.
Yes, they will, Your Honour.
Please proceed. Thank you.
At the outset of any criminal trial, there are a number of matters which are so important that they ought to be restated, however learned the tribunal. And indeed, some of them Your Honour has already restated this morning. The first is that the burden of proving guilt falls upon the prosecution. The defendant does not have to prove his innocence. the prosecution only proves guilt by making the court sure of guilt, beyond reasonable doubt, on evidence presented by the prosecution after opening statements and during the trial itself, and only on the evidence presented by the prosecution at that stage. It may be trite law, but it is nevertheless something that tribunals of fact all over the world are routinely and wisely reminded of, that what the prosecution advocate says during the opening speech, or indeed at any other stage in the case, is not itself evidence, and that is one of the matters that Your Honour has rightly reminded the court. The tribunal of fact, whether judge or jury, should be reminded that the trial process requires them to approach the evidence with an open mind, and to keep that open mind until they have heard all the evidence and listened to all speeches, both at opening and at closing, addressing the evidence. Any assumptions or starting points that they might bring to the courtroom are to be left aside once the trial begins. The only presumption that is appropriate is the presumption of innocence, as Article 21(3) of the law of the Specialist Chambers reminds us. No suspect or accused is required to answer questions posed by the prosecution during the course of any investigation. If questioned, he or she has the right to remain silent, without such silence being considered in the determination of guilt or innocence, as Article 38(3)(b) of the law of the Specialist Chambers restates for us. In the pre-trial stage, the law provides that no defendant before the Specialist Chambers is required to set out the general nature of his defence or the charges and matters the prosecution allege which the accused disputes, and why. The defendant is entitled, as Your Honour reminded each defendant this morning, to remain silent during the course of the trial itself. No defendant is required to testify without such silence being a consideration in the determination of guilt or innocence. These are all fundamentals that should be restated. In the present case, Mr. Smakaj was not interviewed by the SPO about this investigation before he was charged. But he has chosen to set out the general nature of his defence, the charge and matters the prosecution allege which he disputes, and the reasons why he does, in a pre-trial brief dated the 19th of October 2025. He has rightly challenged parts of the transcription and translation of audio recordings in relation to the two specific dates which concern him. I say rightly because, as the SPO knows, that whereas it had prepared this case up until this week and has just presented to the court and to the public a transcript suggesting that Mr. Thaçi had been asked on the 7th of October if papers could be taken from a visit. In fact, that was an error of interpretation by the SPO that the Language Services Unit of this court has confirmed was an error, and that in fact the Speaker asked if he could bring papers in the future. Any assumption that the SPO must be right would be not only inappropriate, improper, and unjust, but also downright misleading. Mr. Smakaj has given the prosecution, chosen to give the prosecution, advance notice of his case at this trial, that although he was friendly with Bislim Zarapi and met him regularly, that he had no discussion with Mr. Zarapi about his testimony in case 6, and he showed him no document about it. And you will hear evidence during the course of the trial that Bislim Zarapi has been spoken to by the SPO, and under affirmation to tell the truth, has confirmed that, as Mr. Smakaj says, they were friendly, they did meet, but he had never been approached and discussed his evidence with Mr. Smakaj. He had not discussed issues related to his testimony with Mr. Smakaj, or indeed anybody else. And Mr. Smakaj had never offered to show him a document, and he never has shown him a document. Mr. Smakaj chose to give the prosecution advance notice of his case at this trial in his pretrial brief, which he did not have to provide, asserting, for example, that he was not aware of any protocol, witness protocol from case 6, or confidentiality order from case 6, or court order protecting the identity of witnesses from court 6, or protective measures decisions from case 06, or whatever type of name given to orders made in case 6 that the prosecution relies upon, and therefore that he could not be aware and was not aware of any disobedience to those orders if that occurred in his presence. And yet no notice is given by the SPO that they intend to produce any evidence during this trial that he was aware of those orders. You will not hear any evidence that he was aware of such witness protocols or confidentiality orders from case 06. Mr. Smakaj chose to give the prosecution advance notice of his case at this trial in his pretrial brief, which he did not have to provide, asserting, for example, that he had never seen the document presumptively labelled by the prosecution as the, in quotation marks, Smakaj document before. A Smakaj document, the so-called Smakaj document, which I note today, the SPO showed publicly without redactions, and therefore one can assume does not contain any confidential material. But Mr. Smakaj gives notice, has given notice, that his case at this trial is that he'd never seen that document before. And yet there is no notice given by the SPO that they intend to adduce any evidence during this trial from a witness setting out where, when, and how the prosecution first came into possession of it. You will not hear, Your Honour, evidence that that document was seized by the SPO from Mr. Smakaj's car. You will be simply shown a picture of a similar looking document in a car attributed to Mr. Smakaj, with no further contextual evidence in relation to it. Mr. Smakaj chose to give the prosecution advance notice that his case at this trial, through his pretrial brief, a document which he did not have to provide, would involve drawing attention to the absence of any fingerprint or DNA analysis in relation to the so-called Smakaj document, as they presumptively label it. And indeed, Your Honour, you will hear agreed evidence that on the 6th of December 2023, the SPO informed the body, the forensic body handling any forensic work in this case, that no fingerprint examination or DNA examination work was requested in relation to the so-called Smakaj document. And you will hear that the SPO, even though Mr. Smakaj has given the prosecution, chose to give the prosecution advance notice of his case at trial, that he'd never seen that document before. The SPO, you will hear, has made no subsequent request for fingerprint or DNA examination relating to that document since they gave instructions that no such examination was to take place. So, from near enough the outset of this investigation, the SPO made clear that no fingerprint or DNA work was to be done in relation to the document that they want the court, Your Honour, to attribute to Mr. Smakaj. And yet they have not sought any such work, even after Mr. Smakaj gave notice that he was asserting at this trial that he'd never seen the document. Why? Any assumption that the SPO can only have come into possession of the so-called Smakaj document in the way that the prosecution advocates have suggested, claimed this morning, would not only be inappropriate, improper and unjust, but it would also be downright misleading. If indeed the SPO can establish that the origin of that document was an electronic file from within the detention unit, a matter which Mr. Smakaj has no knowledge of one way or the other, the evidence will show that any such electronic file could not be turned into a printed document without it passing into the hands of a detention officer. I make no bones about it, Your Honour. The defence case is that an alternative explanation, and it may not be the only one, as to how that document ended up in the hands of the SPO, is that it reached them through a detention officer. And that if it was ever in the car belonging to Mr. Smakaj, it was put there by the SPO solely to attribute it to him. That such alternative explanations would form part of the trial was made clear in the pretrial brief, which Mr. Smakaj chose to serve, giving notice. He did not have to, but given the SPO advance notice that he was asserting that he had never seen that document before. And yet no notice is given by the SPO. You will not hear evidence from any detention officer or search officer to deal with this aspect of the trial. You will not hear, despite what was just asserted to you, any evidence from the prosecution identifying who printed the document, the file described as per avocaten. The evidence that you will receive in the form of P00128, as what Your Honour was led to anticipate, is that only that an account using the anonymous title, DU guest account, was used. You will also hear that the user account used to print documents was shared by both detainee and detention officer alike. You will not hear evidence identifying who printed the file per avocaten, if indeed that document has any relevance in this case. Instead of dealing with matters evidentially, as is the SPO's burden, the SPO instead, rather self-confidently, intends, it is clear, to simply ask this word to take the court, I'll start again. To simply ask this court to take the word of prosecution counsel. It intends to ignore the requirement for the prosecution to prove its case based on the evidence presented after opening statements during the trial itself and on that evidence alone. And it intends to reject the presumption of innocence, invite your honour to do so, and instead adopt an alternative conceit, because that what it is, that the SPO must always be right and must also always be in the right. We, however, are confident on this side of the courtroom that your honour will disappoint the SPO in that regard and instead approach the evidence with an open mind, keeping that open mind until you have heard all the evidence and listened to all the speeches from all parties, and given due heed to the presumption that Mr. Smakaj is innocent unless and until the prosecution proves otherwise on the evidence alone. And that is what we ask for, Your Honour.
Thank you, Mr. Rees. Mr. Edwards, I see we have 19 minutes before the break. Would you be able to commence before then?
Your Honour, I will commence and endeavour to finish. And for the benefit of the interpreters and the stenographers, I'll try to speak slowly. More than 27 months after Isni Kilaj's initial arrest at his home in Malasheva, the town for which he was elected twice mayor, this trial finally starts. For more than 27 months, 18 of which were spent remanded in custody, Mr. Kilaj's life has been on hold. It is hard to overestimate just how much he and his family have been looking forward to this moment, because finally, in open court, the world will see just how paper-thin the prosecution's case against him really is. This case involves 5 accused, 19 counts on an indictment. That carries with it a degree of complexity, to be sure. But focusing in, as I do, on the case against Mr. Kilaj specifically, it is evidentially as simple, as factually uncomplicated as any case before an internationalized court could possibly get. The prosecution's case is built upon a single meeting at the detention unit of this Kosovo Specialist Chamber on the 6th of October 2023. Mr. Kilaj and his friend of many years, Vlasnim Krijezu, visited Mr. Thaçi for a couple of hours. They talked, they joked, they reminisced about the old days, about the war in which they all bravely fought in defense of their beloved Kosovo. They gossiped about people they have all known for decades. As you heard earlier this morning, the prosecution allege that Mr. Thaçi gave Mr. Kilaj instructions to meet with witnesses that were to testify in his case and to tell them what they should say in court and how they should say it. I want to make it very clear that we make absolutely no concession about what Mr. Thaçi did or did not say to Mr. Kilaj. Mr. Kilaj admits nothing about any alleged instructions. As in any criminal court, anywhere in the world, whether in Kosovo, whether in the United Kingdom, whether in Canada, anywhere, the prosecution brings this case, and it is for the prosecution to prove its case, to prove that Mr. Kilaj is guilty as charged. He is not required to prove his innocence. And I make no, I don't seek to excuse myself by repeating what Mr. Rees just said to you a few moments ago, reiterating the importance of the burden and standard of proof, because it is that important. But even if the prosecution does manage to prove what was discussed during the 6th of October visit, there is absolutely no evidence of Mr. Kilaj contacting any witnesses in K6 thereafter, much less any evidence of Mr. Kilaj meeting with any witnesses thereafter, much less still any evidence of Mr. Kilaj telling any witnesses what they should or shouldn't say when they come to testify before this court in Case 6. Your Honour, in the nearly 4 weeks between the meeting on the 6th of October 2023 and Mr. Kilaj's arrest on the 2nd of November 2023, Your Honour will hear not a shred of evidence of anything done by Mr. Kilaj resulting from his visit at the detention unit. Nothing. He left the detention unit on that Friday afternoon and then simply got on with his life in Kosovo for the next 27 days until his life was turned upside down. Not only is there no evidence of Mr. Kilaj doing anything after the 6th of October meeting, there is no evidence of the slightest relevance of any actions undertaken by Mr. Kilaj before the 6th of October meeting that will help you determine criminal intent on his part. After considering what little evidence there is against Mr. Kilaj in this case, Your Honour may feel that the question at the heart of the matter is Mr. Kilaj's intent regarding the 2 counts he faces in count 14 and 15. What lawyers who like to try and sound clever call them mens rea. After presenting what little evidence there is against Mr. Kilaj, the prosecution will ask Your Honour to arrive at inferences about Mr. Kilaj's intent, to draw conclusions based on his conduct about his intent in order to substantiate the 2 counts he faces. But I can tell you, Your Honour, now, the prosecution will give you precisely nothing to allow you to draw the conclusions that they want you to. There is evidence that Your Honour might expect to hear from a prosecution that carries the burden of proving its case, a heavy burden that demands the prosecution to prove its case beyond reasonable doubt. But that evidence in this case will be glaringly conspicuous by its absence. You will hear no evidence of a broader conspiracy of any kind of joint enterprise that Mr. Kilaj is connected to the other men that follow Mr. Thaçi on the indictment, other than through their simple association with Mr. Thaçi. No evidence of association for the purposes of interfering with witnesses. This is not just defense rhetoric in our opening, Your Honor, it's the reality of the case. As you heard, each of these accused had their own group in the indictment. Mr. Kilaj is not alleged to have acted in concert or to have coordinated in any way with Messrs. Smakaj or Thaçi or Kuchi to interfere with any witnesses. You will also hear no evidence from witnesses 3 or 4 that they were contacted by Mr. Kilaj after the 6th of October visit, or indeed from any witness before the 6th of October visit. The prosecution will suggest that Mr. Kilaj mentioned during the visit with Mr. Thaçi that he had spoken to a prosecution witness before that visit. It's not charged, but I'm going to deal with it. Because an important thing to note is this: even taking Mr. Kilaj's alleged words at face value, he said that he met that witness a week before the 6th of October visit, which was well after the witness's testimony in case 6. So it couldn't possibly have been to interfere with his testimony. But returning to witness 4 and the charges in this indictment, not only is there a lack of evidence that Mr. Kilaj contacted him before or after the 6th of October, there is positive evidence that he had not ever been contacted by Mr. Kilaj. In a contact note from January of 2024, witness 4 said that he had last been in contact with Mr. Kilaj in 2017, 2018. He also denied that anyone had tried recently, at that time, January 2024, to discuss his experiences during the war or in any attempt to interfere with his testimony. Those denials were repeated in later contact notes in May and then again in June 2025. This evidence is recorded in contact notes created by prosecution staff and the subject of agreed facts as between the prosecution and the defence. And here I refer to the 4th notification of additional agreed facts filed yesterday. Your Honour, the prosecution has no evidence to undermine the truth of what has been recorded in these contact notes, and indeed it's entirely consistent with the SPO's case. 11 months ago, in a filing 234, 21st of March 2025, in a response to our submissions on provisional release, the prosecution said this regarding its case on witness 4. At paragraph 4 of that filing, they said, in any event, in submitting that recent disclosures show that Kilaj did not meet with witness 4, and that this in turn demonstrates that Kilaj did not participate in a joint effort to influence witness 4's testimony, Kilaj shows a clear misunderstanding of the indictment and the confirmation decision, which are not premised upon Kilaj having met directly with witness 4. The import and significance of that evidence, which the SPO views differently from Kilaj, will be discussed at trial. That's paragraph 10, Your Honour. So here we now are, Friday, the 27th of February, 2026, and we invite the SPO, as promised, to enlighten us as to what the import and significance is of their evidence against Mr. Kilaj, and perhaps more specifically what the import and significance is of the absence of any evidence that he contacted witness 3 or 4. We've listened carefully to the prosecution's opening this morning. I must confess I'm no clearer now as to what the import and significance of the absence of this evidence is. No clearer now than I was a year ago. And we look forward to hearing how the prosecution is going to build their case against Mr. Kilaj, how they will demonstrate, to use the words of learned friend a few moments ago, such a compelling and overwhelming case against him. I'm sure it's unnecessary for me to do this, but with great respect, I urge Your Honour to keep at the front of your mind throughout this short trial that the prosecution's case about the discussions on 6th of October were all about the issuing of instructions to manipulate witness evidence. I reiterate that we make no concessions about what may or may not have been said by anyone during that visit, but there is zero evidence of anyone actually taking steps to manipulate witness evidence. Not even preparatory steps, much less steps that are more than preparatory, which is required for attempt liability. That brings me to the third category of evidence that is conspicuous by its absence. And it's this. The prosecution has taken a decision, a strategic decision, no doubt, not to call any witnesses from case 6. The only prosecution witnesses Your Honour will hear from over the course of the next few days in this 5-handed prosecution case, scheduled for less than a week of trial time, are what might be described as professional witnesses. And it almost sounds like the beginning of a bad joke.
All rise. Please be seated.
Good afternoon. Mr. Edwards?
Thank you, Your Honour. Just before the break, I was about to embark on my next point, which, I was reminding myself that I had been speaking about the lack of evidence of Mr. Kilaj's contact with prosecution witnesses, much less the lack of, much less any evidence of actual obstruction in this case. And we say that that's important because even taking the prosecution's case at its highest, it fatally undermines any suggestion that Mr. Kilaj ever intended to obstruct, or attempt to obstruct, or assist, or agree to obstruct official persons in performing official duties, as is compendiously charged in count 14. Just before the break, I made the point that the case against Mr. Kilaj is factually fairly straightforward, but that simplicity stands in stark contrast to the over-engineered complexity of how count 14 is pleaded, how it's framed. In our pretrial brief, we explore the complexity and, frankly, the unorthodoxy, if not complete novelty, of how count 14 is framed. It rather impressively achieves the seemingly impossible goal of embracing a plethora of different modes of liability concurrently, whilst in fact alleging nothing of substance at all. Your Honour will be familiar with the iterative process of the indictment confirmation. And I'm not going to take Your Honour's time up now by rehearsing the chronology. It's all contained fairly well in your predecessor's confirmation decision. But it's worth noting what the pretrial judge said at paragraph 192 of the confirmation decision, and this is public. The supporting material does not demonstrate that there is a well-grounded suspicion that the acts and statements of Messrs. Thaçi, Fazliu, Smakaj and Kilaj obstructed the work of SC/SPO officials in the context of SC proceedings. So, just pausing there for a moment. We've been waiting, Mr. Kilaj has been waiting 27 months for a trial that is all about obstruction and interference with the administration of justice, but it's already been determined that there is no well-grounded suspicion that obstruction actually happened. And we heard earlier this morning the specialist prosecutor in opening the case stating, I'm sort of paraphrasing, but it doesn't matter if the accused were successful in their efforts to influence witnesses. As a matter of law, that might be right, but Your Honour may think that that is a fairly bold statement designed to manage your expectations about what actually the evidence against Mr. Kilaj shows. This was not the indictment that the specialist prosecutor wanted to run in the first place. This indictment was not the SPO's first choice. It wasn't even their second choice of indictment. The operative indictment was their third bite at the cherry. The prosecution had had to return to the drawing board time and again after each previous version of their indictment was subjected to some judicial scrutiny and found wanting. And what we have now is a count 14, which alleges complex layering that doesn't that just doesn't actually make very much sense. It's torturous. It's bizarre. So we have obstruction of official persons, the substantive underlying ingredient in Article 401. We have participation in the common action of a group, the first tier of a mode of liability required because it's charged under subsection 2. We have attempt as the second tier of a mode of liability charged as a consequence of the pretrial judge finding that actual obstruction was not sustained on the evidence. And then this third tier of alternative theories of liability, whether commission, whether agreement, or assistance. These three alternative theories are simply verbatim replications of the earlier unconformed iterations of the indictment. So I've described it as torturous, I've described it as bizarre, this bizarre layering of one form of mode of liability on top of another achieves nothing in presenting to Your Honour a straightforward, uncomplicated allegation of criminality on the part of Mr. Kilaj, much less, to use the words of my learned friend this morning, a compelling and overwhelming case. We say that rather it acts to obscure, unsuccessfully, the hard truth that there is no evidence of criminality here at all, as far as Mr. Kilaj is concerned. Your Honour is going to have to answer questions such as whether an accused can assist an attempt as opposed to assist the commission of an offence, and if so, what the required intent of the alleged assister has to be. Questions such as, how does one agree to attempt something, to merely attempt something? We suspect that Your Honour will not take very long to conclude that these questions, posed by the framing chosen by the SPO in the drafting of Count 4, simply exposes the insubstantial nature of the allegations against Mr. Kilaj. And as we say in our pre-trial brief, prosecutorial creativity, such as we see here, is often a marker, isn't it, of evidential fragility. And we say that this case here today is a paradigm example of just that phenomenon. I've come to the end. I've been focusing on count 14, but I will address, Your Honour, very briefly on count 15, contempt of court by assisting President Thaçi to disobey court orders, allegedly. And once again, we're in the realm of prosecutorial creativity that crosses into overreach. In one short paragraph in its pre-trial brief, the prosecution state how it is that Mr. Kilaj is alleged to have assisted Mr. Thaçi to commit contempt of court by, firstly, visiting him in the first place, without going to the bother of explaining where Mr. Kilaj was hiding the crystal ball that would have allowed him to know what was going to be discussed. The prosecution rely on the fact that confidential material was discussed without explaining how Mr. Kilaj could have known that the material in question was in fact confidential, or suggesting how Mr. Kilaj could have avoided his own criminal liability for assistance in these circumstances. Rhetorically, I ask, should he have just put his fingers in his ears and hummed loudly so as to not be a participant in the conversation? The prosecution say that criminal liability is established by him receiving and then keeping confidential documents, without explaining how that works, when by that point the alleged contempt of court must have already taken place. Mr. Kilaj, it's a sort of a damned if you do, damned if you don't situation he finds himself in, because the prosecution specifically rely on the fact that witness 4's statement was found torn up and in the bin. That's evidence of Mr. Kilaj disposing of something that he no longer needs or just doesn't want to have in his possession anymore. It's quite a reach for the prosecution to say, aha, there's proof of a guilty mind. He's disposing of incriminating material. How could he have known that he was going to be arrested in the days that follow? Doesn't make sense, Your Honour. So, to reiterate a point that both Mr. Rees made and I made this morning, is for the prosecution to prove its case against Mr. Kilaj and to prove that beyond reasonable doubt. We, Mr. Kilaj, and his legal team are confident that by the end of this very short trial, you will comfortably conclude that the prosecution has not even come close to meeting that standard as far as Mr. Kilaj is concerned. Thank you.
Thank you, Mr. Edwards. I understand from the registry that it will take approximately 15 minutes to implement the protective measures for the witness. So we will now adjourn until 5 minutes to 3. So please do stay in or near the courtroom, and we will recommence then. Thank you.
All rise. All rise. Please be seated.
Just as a matter of scheduling, I expect that we will continue with the witness until 3:55, and then there will be a couple of housekeeping matters to take care of and an opportunity for the parties to raise any issues as they may consider necessary. Court clerk, would you please usher the witness into the courtroom? Good afternoon, Mr. Witness. Can you hear me?
Good afternoon, Your Honor. Yes, I can hear you.
Mr. Witness, you are called to testify before the specialist chambers in the case of the specialist prosecutor versus Thaçi, Smakaj, Kilaj, Fazliu, and Kuchi. As you may know, you have been granted protective measures in this case, and you have been assigned a pseudonym, which means we will not be mentioning your name, but will refer to you as Mr. Witness or Witness 7 to make sure the public does not know your identity. You also have face and voice distortion, which means that no one outside the courtroom watching the broadcast can see your face or hear your real voice during your testimony. When you answer questions that will not reveal your identity, we will do so in open session, which means the public can hear what is being said in the courtroom. When you are asked to describe anything that relates specifically to you or reveals your identity or your position, we will do so in private session. Your testimony will be broadcast with a delay, and we can remove any information from the broadcast that may tend to reveal your identity. Mr. Witness, can you confirm that you understand the measures that are in place to protect your identity?
Yes, Your Honor, I understand.
After you've taken the solemn declaration to tell the truth, you will be asked questions by the SPO and then by the defense. And at the end of your testimony thereafter, I may pose some questions to you. So I invite you, please, to listen carefully to the questions. You're expected to tell the truth. And if you do not understand a question, then please feel free to ask for a clarification. I will now ask you, Mr. Witness, to read the solemn declaration to tell the truth.
Conscious of the significance of my testimony and my legal responsibility, I solemnly declare that I will tell the truth, the whole truth, and nothing but the truth, and that I shall not withhold anything which has come to my knowledge.
Thank you. It is an offense within the jurisdiction of the specialist chambers to give false testimony. And do you understand this?
Yes, I do.
Thank you, Mr. Witness. You are now under oath to tell the truth. And I now call upon the prosecution, Mr. Howling, to take the floor, please.
Thank you, Your Honor, and good afternoon, witness. Your Honor, in order to identify the witness safely, we would ask to briefly go into private session for my initial questions.
Certainly. Private session?
Your Honor, we are now in open session.
Witness, did you previously give 3 declarations to the SPO about this case?
Yes, I did.
And not to be broadcast in accordance with the general rule, please pull up the first page of the first declaration and put it on the screen. And witness, please just wait 1 moment for that item to be pulled up. Witness, focusing on the English version on the left side of the page, is this your first declaration?
Yes, it is.
If we could now pull up the first page of the second declaration and put it on the screen. Witness, is what on the screen, what is on the screen now, your second declaration?
Yes, it is.
And now finally, if we could pull up the first page of the third declaration. Witness, is what is on the screen now your third declaration?
Yes, it is.
Have you recently had an opportunity to refamiliarize yourself with the contents of these declarations?
Yes, I had the opportunity last week.
Do these accurately reflect what you said and what you would say if asked again in court today?
Yes, it is.
Your Honor, having fulfilled the Rule 154 criteria and in accordance with decision F00687, the SPO hereby tenders all 3 declarations in English and Albanian into evidence, along with the associated exhibits identified in footnote 6 of Your Honor's Rule 154 decision.
Any objection?
No objection, Your Honor.
Seeing no objection from the defense, the 3 documents are admitted. Madam Registrar, do you have the ERN numbers? Yes, okay. Then you may proceed, Mr. Halling.
Thank you, Your Honor. The first declaration, Albanian and English version, will receive exhibit number P00168. The second declaration, English and Albanian version, will receive exhibit number P00169. And the third declaration, English and Albanian versions, will receive exhibit number P00170.
Yes, for the 3 associated exhibits, those ERNs can be said in open session, and we would ask that they also be ascribed exhibit numbers.
Thank you, Your Honor. The associated exhibits with the ERN 051775 to 051780 Red 2 will receive exhibit number P00171. the second associated exhibit with the ERN 051765 to 051770, Red 2, Albanian and English version, will receive exhibit number P00172, and the final third associated exhibit with the ERN 053191 TRET, Albanian and English versions, will receive exhibit number P00173. Thank you.
Thank you, Madam Court Officer. Witness, I have some further questions about your declarations. But first, I wanted to ask you about some general procedures that applied during the Thaçi et al. Trial, also known as Case 6. In Case 6, was there a procedure governing defense contacts with SPO witnesses?
Yes, it was.
Were the defense teams in that case able to contact witnesses directly?
No, they weren't.
Did the SPO explain to witnesses that they could not be contacted directly by the defense?
Yes, the SPO explained to the witnesses they cannot be contacted directly.
In Case 6, was there a procedure governing preparation of SPO witnesses?
Yes, there was a procedure in the Case 6.
As part of this witness preparation procedure, were witnesses given their prior statements for review?
Yes, they were given previous statements.
In those preparation sessions, were they given an opportunity to make changes or corrections to those statements?
Yes, they were given opportunity to change or do some redactions.
I'd like to turn now to a couple of discrete points, and we can use your first declaration. If we can now put back on the screen what is now P168, specifically at paragraph 4. And witness, we'll just wait a moment again for this to be put on the screen. Thank you. If we can scroll down so that paragraph 4 is fully visible. Thank you. So witness, as described here at paragraph 4, you've provided a list of Case 6 witness names, codes, and whether they have protective measures. Please describe how you verified this information.
I verified this information in the SPO internal databases in the case map.
Was this the same process you used to verify the witness charts in your second and third declarations?
Yes, it was the same.
In a situation where one of these witnesses discloses to the public that he or she is a witness before testifying, does that person lose protection to which they would otherwise be entitled to receive by the SPO?
No, they don't lose any kind of the protection.
Thank you. And Your Honor, we'll note there for the record paragraph 524 of the Thaçi and Haradinaj trial judgment. If we could now go to paragraph 9 of the first declaration. Here, you are talking about disclosure of certain witness statements to the defense. How did you verify the accuracy of this information?
So, I would like to explain procedure how we did it. We received from the senior prosecutor information which witness statements and which witness names will be disclosed to the defense, and we would call witnesses to inform them about this. I would verify this information also through the SPO databases, and including case map.
Thank you. If we can now go to paragraph 10, which bridges the page in the English. Witness, here you're talking about how SPO resources were expended. Are you describing here general measures the SPO has taken to combat interference in case 6?
Yes, I'm describing the general measures.
Are you in a position to say what SPO resources were spent specifically because of this case?
It's not possible only because of this case. We've had several cases from this, and it's difficult to say specifically for this case.
One of the measures on the other side of the page in paragraph 10, if we can just turn the page, just focusing in particular on rearranging witness order. When witnesses were moved in the case 6 order, would the SPO explain those moves to the case 6 trial panel and parties?
I don't recall.
So were you yourself always privy as to why particular witnesses were moved?
No.
Was the investigation into this case part of your SPO duties?
No, it was not.
Are you familiar with the investigative steps taken in this case?
No, I'm not.
Do you know anything about how the detention center recording transcripts in this case were made?
No, I don't.
I'd now like to ask you about paragraph 11, which you can still see on the screen. Here you're talking about the timing of the testimony of certain witnesses. Was this information verified through the same internal databases you were discussing for previous paragraphs?
Yes, it was verified from the same information.
Was this also how you verified similar testimony information for other witnesses in your second and third declarations?
Yes, it was.
Thank you. This can be taken off the screen. Are you familiar with what KSC travel records for witnesses look like in case 6?
Yes, I am.
Around how long before testimony would case 6 witnesses travel to The Hague?
It's case by case, but let's say between 7 and 10 days before testimony.
Why did the witnesses travel so far in advance of their testimony?
They also need some time for the reading their statements, means for the proofing, and depends how much materials was there, and that depends how many days in advance they should travel here.
Thank you. And when you mentioned proofing in that last answer, is that in reference to witness preparation that you were describing previously?
Yes, that's correct.
So to focus on Rustem Mustafa specifically, you said in that last paragraph of P168 that he testified from 11 July 2023. If the court officer could now please put on the screen SPOE 00408-671 to 00408-675 RED, and specifically page SPOE 00408-674. And if we can scroll down a little to make the attachment visible, thank you. Witness, can you identify what this document is?
Yes, I can.
What is it?
This is a ticket for the trip to The Hague, usual for the witnesses who were coming to testify in The Hague.
And so, is this a KSC travel record of the kind you were just describing?
Yes, it was.
Now you see here Rustam Mustafa's name and a travel date of 4 July 2023, or 1 week before the 11 July testimony. Is this travel itinerary consistent with the Case 6 witness procedures you just described?
Yes, it is.
Your Honor, we would tender this item for admission into evidence.
Any objection from the defense?
No objection.
I see no objection from any of the other defense teams. Therefore, this document is admitted.
Thank you, Your Honor. A document with the ERN SPOE 00408671 to 00408675 read. We receive exhibit number P00174. Thank you.
Thank you, Your Honor. Thank you, witness. No further questions.
Ms. Ménégon, I understand that you previously estimated 2 hours of cross-examination for this witness?
Yes, Your Honor, indeed. Given the time that we are at, I would respectfully ask leave to start my cross-examination on Monday. You had indicated in your filing F705, paragraph 8, that if we consider that we are not sufficiently prepared for cross-examination, we could ask for such a postponement. We would appreciate to have this a limited extra time in order to streamline our cross-examination, especially because there have been a lot of discussions with the other party regarding aggregate facts, which may have an impact as to the scope of my cross-examination. And I don't think it would be prejudicial for any party, and it would be in the interest of a good administration of justice. Thank you.
Yes, and in the decision 705, I had anticipated that any request for an adjournment would be made somewhat further in advance than at the moment that the cross-examination was expected to begin.
Yeah, I was not sure about the length of the progress of this of today, and also since we had some delays this morning, this is also why I'm asking for that now. Thank you.
And I don't suppose any other defense teams are ready to proceed with the cross-examination at this time.
No, in fact, I support the application that's made by Ms. Ménégon.
All right. Well, in that case, we will adjourn the hearing for today. However, there are some procedural matters I would like to address before we adjourn. So, Mr. Witness, that concludes your testimony for today. You will resume your testimony on Monday. Thank you very much for being here today. Let me remind you that until Monday, you are not to discuss your testimony with anyone, and you'll now be assisted by the registry to leave the courtroom. Thank you.
Thank you.
And, Your Honor, just before reaching those procedural matters, we understand the ruling that the defense won't be cross-examining today. We also appreciate that the nature of that means that they may seek to supplement their presentation queue items over the weekend as they prepare. However, we would think that if they have presentation queue items now, they should have been on notice to at least release what they were planning to notify as of this moment. And we would ask that those presentation queues be released to the extent they exist.
Well, let me first of all ask the the Thaçi defense whether, or as of what moment in time over the weekend they would be in a position to release their presentation cue.
We have prepared one already that we are able to release. It's just that we may withdraw some items. I mean, in light of our effort to streamline our cross-examination, we may withdraw some items. We may add some more, probably not, but we may withdraw some. So.
Well, in that case, I do think it would be appropriate if the presentation cue were to be released at this point.
It's fine with me.
Thank you very much. Before I deal with my one housekeeping matter, may I ask whether or not there are any issues from the parties that need to be addressed?
Your Honour, can I just raise a very short matter in relation to something that will occur on Monday? It's simply to say that given the evidence we've just heard from the witness, I think it's very likely that I will ask the court to briefly sit again in private session so that I can explore with the court or the witness some of the evidence he's given about what evidence he can give, because he's obviously given an indication about what he was instructed to do and what he didn't do and what he didn't know about. So I'd like to explore that with the witness. I think it would be sensible to do it in private session, because otherwise it might tend to reveal his identity. Thank you.
Yes, and in fact, would it be appropriate, and here I'm addressing the Thaçi defense, to start the cross-examination on Monday morning in private session?
I will have some introductory questions in open session, but really shortly I will move between private and open session regularly.
I should add we're releasing our presentation cue now.
Thank you. That's noted, and of course we will move into private session as necessary.
Your Honour,
yes.
One matter that I would wish to raise, if this is a convenient time. It's simply in relation to the outstanding motion that we filed seeking redactions to remove material that does not, in fact, appear on the audio recordings from the transcripts of the 9th of September and the 7th of October 2023 as F00747. So I'll say that again, F00747. The question that I would wish to raise is to ask Your Honour if Your Honour is in a position to let us know when we might anticipate Your Honour's decision. It will have an impact, or may have an impact, on the extent, if any, of cross-examination that I have for this witness. So that's why I raise it at this point, Your Honour.
I understand. And I believe we received the reply on Thursday or Wednesday of this week?
Certainly, it was, there was a expedited timetable that Your Honour set down to deal with the filings, but the SPO's response and the reply were filed in accordance with that timetable, and Your Honour has it.
I can't promise, Mr. Rees, that we'll have a decision out by the end of Monday. I can only say that it's under consideration and we'll do our best. But
well, I'm very grateful for that, and I don't intend to put any pressure, of course, on Your Honour. On the contrary, I urge Your Honour to take such time as is appropriate to deal with it. But it may be that in those circumstances, I would ask on
in the start of proceedings, and I didn't really have an opportunity to address Your Honour about it, but there was a difficulty involving public transport in The Hague and some confusion about tram routes, and that was the reason for the late arrival of Mr. Kilaj. So we apologise and thank the court for its patience in waiting for his arrival, but it won't happen again.
Thank you, Mr. Edwards. That's very much appreciated. So before we adjourn, I do have one housekeeping issue, which is an oral order. I recall that in the decision on the conduct of proceedings, F642, I instructed the Thaçi defense to file a public redacted version of F567 or request its reclassification as public by 30 January 2026. On 4 February 2026, I reminded the Thaçi defense of this via email correspondence. Today, I order the Thaçi defense to file a public redacted version of F567 or to request its reclassification as public by 4 March 2026. This concludes the oral order.
All rise.